Permitted to make a mention, my lord. Well, there's item number 49 in today's list, my lord, supplementary. In the second supplementary list, my lord. The matter relates to, my lord, appointment of member of the Arunachal Public Service Commission, my lord, and thereafter recalling the appointment. Lord, similar petition we have also appeal, we have also filed, my lord. Can I pray both the matters may be taken up tomorrow, my lord? The one is listed, one is not listed.
Where is the counsel for the?
Yes, my lord, I have informed.
Is it okay?
They're agreeable, my lord.
We'll give you the permission for listing.
Yes, my lord.
All right.
Deeply.
We'll take up this matter tomorrow.
Tomorrow, my lord.
49 tomorrow.
Deeply obliged.
Yes, my lord, item 2 and 3, these two matters may kindly be taken at 2 p.m. my lord.
Why?
Because my lord, one copy is not found. I have sent my junior. 2 p.m. my lord.
Basically, you are saying CBI investigation, have a look at the postmortem report. Nothing more is required. That is conclusive. It is a case of suicide, plain and simple. You can't go beyond that.
Even then they are liable because that was done inside the district.
So, all
jail.
right, for that the FIR is registered already. So what evidence of abatement will come in?
No, my lord, Supreme Court says that even if the person has committed suicide inside the authority of the state instrumentality, they are liable. They are liable.
Understood. So for that the prosecution is going on. All right,
No.
we'll take it at 2, not an issue.
2 p.m.
Okay.
May I please allow?
Item number 1, my lord.
Let it be called out, please. Let it.
And-
Why have you not filed the affidavit?
My lord,
Why the affidavit has not been filed?
Lordship, it is central waiting of them.
We've given ample time. The order was passed in 2020.
Lordship,
Why it takes so long?
a week time, Lordship, it's central waiting of them.
When council MS so representing the respondent number 4 secretary, KAC,
no, ACD
No.
department. ACD department.
ACD department,
Hills Area Development Department.
Hills Area Development, HAD department submits that affidavit to be filed on behalf of such respondent is ready and would be filed within next 7 days.
Okay.
List on 20th June.
I'd like to mention item number 34, my lord.
Yes.
Lordship, issued a direction to file the affidavit, my lord, by the principal secretary.
Uh-huh.
I have sent it for vetting, my lord. Lordship, 10 days time may be granted, my lord. I've
Mr.
taken the. contact of-
Standing Counsel, Mr. J. Chutia, appearing for the council, submits that affidavit as directed to be filed on behalf of the secretary, principal secretary, KAC is ready, and the same would be filed within next 7 days,
10 days.
next 10 days. List on 20th June as printed.
The victim is item number 33. my lord.
Sir, we have called out 4 to 13.
All. 27
years.
Malad, in item number 16 to 17, 16 and 17, Malad.
Hmm.
Malad, we have filed a review petition, and on last occasion I mentioned that the review petition may be listed. It is numbered. I have picked up. the-
Otherwise also,
Lordship.
what we find is this is not a matter to be taken up by division bench.
The item number 16 is not.
So
17 is the
yes,
contempt.
why it comes to the division bench, sir?
Oh, my lord, I'm for item 37.
No, I have, no, my friend possibly is not here.
Item number 16, who is the petitioner's counsel?
Malad,
Let it be called out.
I talked to him, Malad, I talked to him and I informed him that taken the consensus that I'll mention the matter for the review to be listed.
So you have communicated that you will be mentioning,
Correct.
but we can send it to the single bench,
Malad,
all the council,
Lordship has said, Lordship, I'll-
because
I'll
there is no rule under challenge, there is no statute under
No.
challenge.
No.
Why it is required to be considered by,
Correct, correct.
call the council.
Lordship, I'll inform.
Yes,
Lordship.
Yeah, I'd like to mention item number 33. my lord.
yes, please.
Right.
Why, sir, 2019 matter pending for admission? Why do you want an adjournment?
I could not prepare my name.
Hmm?
I could not prepare it fully. my lord.
couldn't prepare for last 4 years, the matter is petition.
Yeah. Hello.
My lord, I'm appearing for the Inland Water Transport Department, item number 33, my lord.
Yes.
My lord, we have given our consent for adjournment, my lord, and my seniors was not with me.
Counsel for the appellant petitioner has circulated an adjournment slip. The other side has no objection. List up to 6 weeks.
Wait, please, your lordship.
Yes.
Lordship, like to mention, item 37 and 38. Lordship.
37, 38. Yes,
37 and
please.
38. My lord.
Yes.
My lord, the state has filed their affidavit yesterday. We
Mm.
have received a copy. My lord, counter has to be filed here. My lord.
Affidavit on behalf of the state authorities has been filed yesterday. The petition appellant's counsel prays for and is granted 2 weeks, 4 weeks time to file counter there too.
There was an interim order not to pay the salary, lordship.
Not to
Pay the salary, that may be extended, lordship.
My lord, I'm the respondent. They're the appellant. My lord.
for the respondent kar dijiyega. The ad interim order related so and so shall remain in currency till next date. List after 6 weeks.
Obliged.
May please your lord.
Mhm.
I am praying for listing a new matter, my lord, tomorrow, my lord.
What is the matter, sir?
Lord, regarding my lord, no confidence motion, my lord,
Mm.
we move a no confidence motion, my lord, against the president.
Mm.
And the president, my lord, challenged the same, my lord, before the single, learned single just, my lord.
Mm.
And matter was remanded
Mm.
for fresh meeting.
Okay.
Again, fresh meeting was held
Mm.
and no confidence was passed.
Then.
Again, my lord, the president challenged the same.
Okay.
Now, my lord, again, my lord, the learned single just, my lord, remanded the matter, fixing 12, my lord, for meeting.
Okay. So let the meeting take place. What is the problem?
My lord, meeting was held, my lord, in the month of September 2022.
So if the
And now
procedure is not
again
followed,
remanded.
if the procedure is not followed, these are just technical matters.
Lordship.
So if the procedure is not followed, the meeting has to be reconvened.
Meeting
Full bench
was-
of this court says so.
my lord, the meeting was held as per direction of this honorable court, my lord, by complying all
You have
the requirements.
All right, get it listed on Friday.
Developed.
So may I interrupt, lordship? Can it be on, in the last item, after 2 weeks, lordship?
Which one?
47.
Item 37, 38.
2 weeks. Why? You are enjoying a stay. What is the problem?
May I please, your lord?
Now you have to see there are only 15 days left before vacations.
Lordship.
You can't have all random matters listed like this.
May I please, lordship? Lordship, beg to mention listing a writ petition, lordship. Next week, lordship.
Listing
Yes, lordship.
what petition?
Lordship, we have challenged the validity of the rule of plastic waste management rule, lordship.
Plastic waste management rules. All right, get it listed in the next week,
Monday, lordship.
Monday.
Obliged.
May I please, your lordship? I beg to mention for listing for orders, your lordship, contempt matter. your lordship.
Contempt matter. Tuesday, Monday.
Much.
Daily list from item number 4 to 7.
Lordship, at the last occasion, I was directed to take research on the point whether section 17A is required
Mm.
to be followed
Mm.
for investigation into the case which has been directed by this honorable court.
Yes.
What I like to place to judgment of, though it is not binding, of Kerala High Court, Lordship,
Okay.
where all the laws have been discussed, Lordship.
Let's see. Let's see.
It is, Lordship may kindly come to paragraph 90, Lordship.
Just.
Yes.
Para 19,
Around 19, okay.
yes.
The issue for, may I read, Lordship? The issue for consideration before this constitutional bench in CPDR judgment I've already placed before this honorable court, was whether the High Court in exercise of its jurisdiction under Article 226 of the Constitution of India could direct the Central Bureau of Investigation established under DSP Act to investigate into the cognizable offence which is alleged to have been taken place within the territorial jurisdiction of the state without the consent of the state government. Section 5 of the DSP Act empowers the central government to extend the power and jurisdiction of special police establishment to any area in a state. Section 6 of the DSP Act provided that nothing contained in Section 5 shall be deemed to enable any member of the Delhi Police Establishment Act to exercise power and jurisdiction in any area in a state without the consent of the government of the state. After noticing the scope and amplitude of Section 5 and 6 of DSP Act, the Constitution bench answered the question as follows.
So now, Mr. Aloy,
Yes,
issue is, this situation is not prevailing in the present case. You are asking for registration of the case. You are a police officer.
Lordship,
The court is not so moto directing.
Lordship, if your Lordship goes to the order passed by this division bench, Lordship may kindly come for a moment.
So your IA basically is that you are asking for registration of
Right,
case.
Lordship, that arose because of the decision made by the Lord single judge. That
Yes.
decision is begun from
Which
that-
is under challenge. Which is under challenge. So we have to first examine the appeal. Even if we assume that this view is correct, what is the fate in Supreme Court? Whether this order was carried to Supreme Court or not?
No, Lordship.
You have checked.
Actually, time was very short, Lordship.
You have to check first.
Even, yes.
This order must have been challenged.
Yes.
We are sure. So
This-
irrespective of that,
Lordship, this is not the only order. In Bombay High Court also same order has been passed.
we
I
understand.
verified, Lordship.
So the fact remains that the High Court in the exercise of the high prerogative writ jurisdiction can direct. But this is a prayer by the police officer.
Right, Lordship. That arose because of the order passed by Lord single judge.
So that is under challenge.
Yes.
Problem is there. Problem lies there. So we'll have to examine the writ appeals first.
That apart, Lordship, one more thing I would like to submit before Lordship. At the time when this honorable court direct the CBI to conduct a preliminary inquiry, that amended act was not in force, Lordship.
Amended.
Act was not in force, Lordship. It comes into force after 2018, Lordship.
So offenses took place before that.
Yes, 2005 and 6, Lordship. Therefore, that is the.
Okay, yes, that is an issue, yes,
Yes, Lordship.
which needs to be considered. Yes.
So that is
Okay.
the thing,
What do you
Lordship.
say, Mr. Chaudhary?
My
The
lord,
preliminary inquiry was
no,
conducted
my lord,
before coming
my
into
lord, we
force.
kindly come to one order passed by learned single judge of this honorable court.
Where is it?
At page 76, 72, my lord, of IA 1887 of 2020. In fact, my lord, they filed a petition. This is the order which is passed.
Petition for?
For my lord, giving permission to them. Kindly come to my lord, page number 76. The second subpara, my lord. In view of the submission made by the learned ASGI, it would not be necessary for this court to go into the merit of the contentious issues raised in the writ petition. With the consent of both the parties, I therefore dispose of the writ petition at the stage of motion hearing by granting leave to the CBI to take immediate steps for obtaining approval under 17A of the Amendment Act of 2018, read with Section 6 of the DSP Act from the concerned authority.
This aspect was not considered, that the offense having been committed much before coming into force of the act,
My
whether
lord,
any such permission would be
Section
required.
6 would be there, my lord.
Yes, 6 is all right. 6, 2 to 6,
My
we
lord,
can very well give
My
the
lord,
direction.
my humble submission is very
Yes.
simple, my lord. The division bench order which directed a preliminary investigation.
That was before
inquiry,
coming into
that
force.
that cannot be construed as a, my lord, direction by
It's a
this honorable-
continuing course of action, Mr. Chaudhary.
my lord.
That action started in the old act, so it has to culminate under the old act.
Yes.
The 17 is prospective in nature.
Even if we give up section 17 capital A, my lord,
Yes.
section 6 is very much there.
So for that purpose, the High
And my
Court is
lord,
empowered.
and my lord, now the issue is, I
Hmm.
think somebody has to challenge the order by which the government of Arunachal Pradesh has declined permission.
Under
That-
17A, which is not required.
No, under section 6 also, my lord.
No,
both.
so 6, when we
Okay.
excise our jurisdiction, that order will go suo moto.
No, my lord, that lordship has not directed criminal investigation by CBI. All that was directed was only a preliminary inquiry. Now, my lord, here is
Preliminary
a
inquiry results into collection of evidence,
No, my lord.
disclosing
My
commission of cognizable
in the
offences.
in the order whereby the permission was declined,
Hmm.
a detailed speaking order has been passed.
Hmm.
Lordship will kindly have a look. My lord, what had happened? The basic allegation is, my lord, no tenders were issued.
Hmm.
That's the basic allegation. My lord, in this
All
state
work
of,
orders were given to family members, sir.
my lord,
The public
in
money,
this
it's ultimately, Mr.
state of-
Chaudhary,
my lord,
it's the taxpayers' money, it's your money, it's my money.
no, my lord, I appreciate.
It's being pilfered like anything.
No, my lord, here in this case, it is not a case where the works were not done or something.
Oh.
Tender issue, my lord, it only became the operation.
How many times, how many times have you visited Arunachal?
There was a time I used to visit quite often, my lord. Nowadays I get from. Recently,
Please have a look at that state. What money has been pumped in and what has resulted.
that is there.
Don't ask us to comment on that. It's preposterous, we will say. So unless these people who have indulged in this pilferage, they are brought to the book, nothing is going to improve. So let the CBI investigate what is the problem.
No, my lord. My lord, we have declined. Question is, my lord, that order is not in challenge, under challenge.
What do you say
There
about
only,
that?
there's.
Where is that order?
Yes,
Where is the order?
yes.
Is
my
it on
lord.
record?
Yeah, it's on record, my lord.
Or in which item?
Yes. My lord, that order is at page number 95. 97.
So that order is
same IMI.
declined on the premise that 17A applies. We'll clarify 17A has no application at all. You have not declined permission under 6.
No, my lord, the report is of 2019.
Or maybe the proceeding started earlier, the offences took place earlier. Mr. Aloy,
Yes.
to come prepared on the aspect
No, my
that
lord.
where the process started before coming into force of the act,
Yes.
the act of 2018, the amended PC act, and the offences also took place earlier, then 17 would not apply. Come with the law on that aspect. We post it on next Tuesday. List on next Thursday laga dijiye.
Could it be on Thursday, my lord? Thursday, my lord.
Thursday?
Thursday.
Thursday, all right.
About-
You address the court on this aspect.
My lord, we'll do that.
Yes, 15th June. Law is well settled. Procedural laws,
Yes, Article
unless
20,
specific, yes,
Article 20 sub-article.
yes. So it can't be retrospective.
Yes.
And herein the process was set into motion earlier. Very well. Come.
When the order was passed by this honorable court, 17A was not there, lordship. Therefore, lordship, earlier it will prevail, lordship.
It was not your argument so far. All right. Come prepared on that.
Earlier.
Item number 8.
Wait, please. The papers are very voluminous, but the issue is not so.
Very small.
In fact,
Your
honorable-
consortium has
and John,
fallen apart.
but since the honorable single judge has not entered into the merits, I won't trouble your lordship on the merits.
Yes.
What had happened was the tender clauses.
All right, before you proceed, what has happened to the work in question?
Work is going on.
Is proceeding,
Yes.
work in progress.
Yes.
All right.
That is why there's an I am not praying for an interview.
Yes.
What had happened was the tender clauses permitted participation as a consortium. In
Yes.
fact, the entire burden was put on the lead partner. And there was a specific clause saying that only in the event of the contract being awarded, you have to enter into a definitive agreement with the consortium partner. Accordingly, the lead partner took all the responsibility, participated. And thereafter, our tender was rejected.
Hmm.
When we filed the writ petition
Yes.
for various issues, business issues, the consortium partner did not, it supported us all through. It has in fact
But
filed. an
before that,
additional-
it had transferred its business.
No, that issue has been held in my favor by the Honorable Single Judge. That issue I am not even going into. But what had happened was, I
Yes.
filed the writ petition on my own with the consortium partner being a pro forma respondent.
Yes.
An objection was raised that the writ petition would not be maintainable. And my submission before the Honorable Single Judge, which has been up to para 39, it has been accepted. In fact, may I straight away place the judgment, your lordship will find. If your lordship will kindly turn to the impugned judgment straight away, it starts at page 104, my lord.
Para?
If your lordship will first come to para 7, this was my argument. Para 7 at page 111.
The tender conditions were changed while the process, after the process had been started. Is your case that to suit the successful bidder?
That is on merits. I won't trouble your lordship on merits because the Honorable Single Judge did not enter into the merits.
Okay.
But on the issue of maintainability, this was my submission. Para 7.
Yes.
Mr. I. Chaudhary, the senior counsel for the petitioner, submitted that the consortium comprising of petitioner number 1 and the pro forma respondent number 7 is not a joint venture, but only a consortium, whereby the petitioner number 1, in order to be eligible, had taken the credentials of the pro forma respondent number 7 for fulfilling the commercial criteria, the technical criteria, as well as the financial criteria enumerated in clause so and so respectively. The learned senior counsel for the petitioner submitted that in terms of with clause 3.5.6 of the notice inviting tender, various conditions have been mentioned as regards the consortium formation. The learned senior counsel for the petitioner submitted the subclause C of clause 3.5.6 stipulates that consortium must be valid for a period, minimum period of 12 months after the completion of the contract, and the termination of the consortium agreement or any material change in the consortium agreement before the minimum period of 12 months shall be considered as the breach of the contract agreement and legal action would be initiated.
Para 7, please.
My lord,
Para 5, para 5.
My lord, my main submission on the question of law is recorded at para 9.
Para 5, please, first. Satisfy us on that.
This court, after hearing the learned counsel for the parties on the preliminary objections taken by the respondent number 6 as regards the maintainability of the writ petition on so and so, granted the liberty to the petitioners to transpose the pro forma respondent number 7 as a court. That is true. We did not, the consortium partner did not want to join as a petitioner. On the question of law, my submission is recorded at para 9. And this contention has been accepted by the Honorable Single Judge.
Yes, read.
Para 9. Drawing attention of this court to the various clauses of the tender documents as well as the MOU, the learned senior counsel submitted that there is a difference between the terms consortium and joint venture. Inviting the attention of this court to the judgment of the Supreme Court of India in the case of New Horizons, etc. The learned senior counsel submitted that while in the case of joint venture, a separate and distinct entity gets created, whereas in the case of a consortium, since there is no sharing of profit and losses, the lead partner continues to retain its individual character, and the other partner merely plays the supporting role for the purpose of executing certain aspects of the contract in question. And therefore, the lead partner, who is the petitioner number 1 in the instant case, being aggrieved, can maintain a writ petition challenging the illegal actions of the respondent authority. This was my argument, madam, and this has been accepted by the Honorable Single Judge by relying on a catena of judgments.
Yes.
If your lordship kindly comes to para 33 first. Para 23 first. It's at page 128. Has my lord scouted?
Yes, yes, read.
Mal. After having considered all the relevant judgments on the issue, this is what the Honorable Single Judge has held. In all the above definitions, as well as the observations made by the Supreme Court in various judgments, one aspect is clear, that sharing of profit is one of the preconditions to hold that the said combination of persons, natural or juristic, to be a joint venture. The Supreme Court in the case of so-and-so, while considering the concept of a joint venture by taking into consideration the various definitions as well as the observations made by the Supreme Court in New Horizons, had given an illustration in paragraph 25, thereby explaining the concept of joint venture. Para 25 of the said judgment is reproduced here in below. An illustration of joint venture may be of some assistance. An agreement between the owner of land and a builder for construction of apartments and sale of those apartments. So as
para 27, please.
Mal. Para, your lordship is on para 37.
27.
27.
Yes.
Let this court therefore analyze in the above perspective as to whether the petitioner number one can be held to be a joint venture or consortium of bidder. For the said purpose, it would be relevant to analyze some of the relevant documents enclosed to the tender by the petitioner number one consortium with specific reference to the terms and conditions of the tender documents. A perusal of the terms of the notice inviting tender do not define the term bidder. However, clause 3 of the NIT stipulates the bidders who meet all the criteria specified in the clauses shall be qualified for participating in the tender and shall submit supporting documents as detailed in the NIT. Clause 3.1 relates to technical criteria. Clause 3.2 relates to commercial criteria. Clause 3.3 pertains to financial criteria. Clause 3.5 is in relation to general notes on bidders' qualification criteria, etc. In clause 3.5.6, it has been mentioned that the consortium formation shall be allowed subject to meeting conditions mentioned in subclauses A to X. Therefore, in view of clause 3.5.6, a consortium can very well submit the tender subject to the conditions mentioned in 3.5.6. It has been mentioned in subclause A of clause 3.5.6 that bidders are allowed to form a consortium for bidding against part A or for bidding against part A and B together. In subclause C of 3.5.6, it is mentioned that the consortium must be valid for a minimum period of 12 months after completion of the contract. The termination of the contract, consortium agreement or any material change in the consortium agreement before the minimum period of 12 months shall be considered as breach of the contract agreement and legal action would be initiated. Subclause D of 3.5.6 stipulates that either one or both the consortium partners shall have to meet the criteria specified in 3.1 and clause 3.2 individually or jointly subject to subclauses 1 to 5. Now, my lord, if your lordship kindly comes to para 33,
Yes.
what really is, if your lordship first has para 33,
Yes.
these two paragraphs will make the position clear what the honorable single judge has held so far as the petitioner is concerned. Para 33. Therefore, a perusal of the MOU entered between the petitioner number 1 and the pro forma respondent number 7, it cannot be said that the consortium so formed is a joint venture. This is a conclusive finding by the honorable single judge. And if your lordship now turns to para 37.
Before that, come to para 35, last
35.
last 7 lines.
Two other documents.
It is also relevant, last 10 lines. It is also relevant to take note that in the power of attorney.
My lord.
Yes, it has been mentioned.
Power of attorney, it has been mentioned that the power of attorney shall remain valid until NRL receives a written notice from the pro forma respondent number 7 withdrawing the authorization, or NRL, that is the respondent number 3, communicates or the company, that is the pro forma respondent number 7, comes to know that the tender is not awarded to the respondent number 7. The second power of attorney dated so-and-so is in similar terms, except the fact that by the said power of attorney, Mr. So-and-so, as well as Mr. So-and-so were appointed to represent the pro forma respondent number 7 in the said tender. There is no denial to the fact that the pro forma respondent number 7 is in know that the tender had not been awarded to the pro forma respondent number 7. And as such, as on the date of filing of the petition, the said power of attorney ceased to exist. This is factually, I am not
And then
disputing.
para 36, non-challenge to the award by the respondent number 7. That is held to be the crucial factor.
But my lord, the reason I have been non-suited is not that. What has been held is that we are not a consortium. We are not a joint venture. We are a consortium.
Yes.
At para 37, if your lordship kindly peruse this,
Yes, yes.
there's a conclusive finding to that.
Para 36 is
36,
more relevant.
my lord, at this stage, this court would like to take into account the submission made by the learned counsel for the petitioner to the effect that the said power of attorney continue to remain in force as much as the tender has been illegally awarded to the respondent number 6, and as such, the same being non-est and void ab initio, the power of attorneys continue to hold the field. In the opinion of this court, the said submission is totally misconceived, more so when the pro forma respondent number 7, having not assailed the action of the respondents 3 and 4 to award the contract to the respondent number 6, thereby accepting that the said tender has not been awarded to the pro forma respondent number 7. Under such circumstances, the power of attorneys has closed as annexure so-and-so to the bid submitted by the consortium of the petitioner number 1 and the pro forma respondent number 7 cannot be construed to exist as on the filing of the writ petition. Furthermore, there is no power given to initiate proceedings assailing the tender process as well as the allotment of the contract to the respondent number 6. And while considering this issue of power of attorneys, what the honorable single judge entirely overlooked was the agreement, consortium agreement, which said that it is irrevocable, which was the requirement of the tender clauses.
Yes.
Now, based on that, my lord, at para 37, what has been held is this one.
Yes.
In the backdrop of the above, it is clear that the bid submitted by the petitioner number 1 and the proforma respondents number 7 as a consortium is not a bid as a joint venture, and it is merely a bid as a consortium of bidders. The materials on record shows that both the petitioner number 1 and the proforma respondent number 7 are jointly and severally responsible. It is only for the sake of convenience, as could be seen from clause 3.5.6, that the prime member has been obligated with additional responsibility. However, each of the consortium members continues to be responsible. The MOU do not specify anything about sharing of profits in terms with clause 3.5.8. The definitive agreement to be entered into has to be in consonance with the MOU. It would be seen that there is no participation of profits mentioned. Therefore, each of the consortium members, as per the MOU, would be entitled to the respective profits in terms with the distribution of works as mentioned in Annexure 1 to the MOU. Therefore, as per the MOU, each of the consortium members would act as independent contractors while executing the contract if awarded. Now, having held that we are not a joint venture, my lord, in my humble understanding, the Honorable Single Judge committed the error is a para 39.
Yes.
Having held that we are not a joint venture and we are a consortium, the Honorable Single Judge went back to relying on a judgment pertaining to a joint venture at para 39, if your lordship sees. In fact, that judgment itself is quoted as well. The natural corollary to the above is that the petitioner number 1 alone does not have a legal right to challenge the tender process, the tender conditions, as well as the award of the contract. At the cost of repetition, it is reiterated that the petitioner number 1, along with the proforma respondent number 7, can only be regarded as a bidder. Under such circumstances, the petitioner number 1 alone cannot be a person aggrieved to maintain the present writ petition. At this stage, this court finds it relevant to take note of a judgment of this court rendered in the case of so-and-so, reported in 2022 1 GLR 715. In the said case, one of the constituents of a joint venture, but not the joint venture, filed a writ petition challenging the allotment of the contract. This court dismissed the writ petition inter alia on the ground of maintainability. Para so-and-so being relevant are quoted here and below. And in the quoted paras, your lordship will find that here, there was no agreement which said that it is irrevocable, unlike in our case. In fact, it is just contrary. If your lordship peruses the extracted portions, well, a preliminary objection was raised by Mr. Das, learned senior counsel for the respondent number 5 in respect of locus standi of the petitioner to file the writ petition challenging the tender evaluation process, wherein the petitioner was not the participant as a single entity, rather it participated as a joint venture, along with Messrs. So-and-so. On perusal of the writ petition, it is found that the petitioner number 1, so-and-so, a limited company, and the lead partners in so-and-so, it is stated that the writ petition, in the writ petition, that the petitioner number 1 authorized the petitioner number 2, the executive officer.
Chaudhary, come to para 34. How was the distribution of work defined in your bid? So if one of the persons who is to do a certain section of work is not aggrieved by the award of contract to the respondent number 7, respondent number 6, how you alone can challenge that decision?
But that is why there was an additional, for that we have put it on record for various business reasons.
You see, now the situation is that the respondent number 7 has sold off its business. So even assuming for the moment that your arguments are accepted, who will execute the second part of the
that has been dealt with by the Honorable Single Judge. If your lordship kindly comes to that portion.
Yes.
Para 42, that issue has been dealt with.
Yes.
And that has not been put to challenge by the respondents. The second broad question involves 2 sub-questions as to whether the selling of the project logistic division, which is an admitted fact, has any nexus with the bid.
No, that is on suppression. We are not on suppression.
No,
we are on the consequence.
Consequence is dealt with at the next parameter. Under such circumstances, this court is not in a position to hold that the sale made by the proforma respondent number 7 of its project logistic business division had any impact on the eligibility of the bid by the consortium of the petitioner number 1 and the proforma respondent.
No, we feel that even that finding is not valid in view of the fact that the clause 3.5.6 stipulates that the consortium must be valid for a minimum period of 12 months after the completion of the contract. So assuming that you had been awarded the contract, as on date, there is no valid consortium because your lead partner, one of your partners has sold off its business. So how do you survive in the capacity of a consortium for 12 months after completion?
That will not have any effect. And secondly, my lord, there is a additional affidavit. If my lord will kindly come to volume 5, my lord,
yes,
of the paperwork.
Read, please.
There
read.
is a document annexed by the respondent number 7, pro forma respondent number 7.
Yes.
This is with reference to the memorandum of understanding between Prism Logistics and All Cargo. All Cargo is the respondent number 7. Virtue of which Prism and All Cargo were acting as consortium members to tender of Technic India Limited for Numaligarh Refinery Limited bearing number so and so, acted as lead bidder of the consortium for this tender. As per this MOU, All Cargo Limited is part of the consortium. This is to reconfirm that All Cargo Logistics Limited is an entity in itself and is fully functional as freight forwarding and logistics service provider as on date of this letter and is fully capable to perform the scope outlined in the record.
How would it do so, sir? It's on record. It's not even disputed that it has sold off its business.
It is a part of the logistics one that will not impact. But
Anyhow, okay, now you carry on with your arguments. Yes.
The main submission is,
Yes.
since the Honorable Single Judge has confined to the issue of maintainability entirely on the basis of
Yes.
whether we are a joint venture or a consortium. The reliance placed by the Honorable Single Judge at para 39 on a judgment pertaining to joint venture and thereby non-suiting us is where the error has crept in.
Very well. Okay.
And in that, just one aspect, even on by reliance on that judgment, there is a very fundamental factual difference which I wanted to bring it to your lordship's notice. If your lordship will kindly come back to the extracted portion on page 139. Para 39.
Yes.
Where it is extracted. If your lordship will come to para 41 of the extracted judgment, there is one very fundamental difference.
Yes.
On perusal of the writ petition, it is found that the petitioner number 1 is so-and-so, a limited company and lead partner in so-and-so. And it is stated in the writ petition that the petitioner number 1 authorized the petitioner number 2, the executive officer, to represent the company, petitioner number 1. I have perused the joint venture agreement of the petitioner number 1 and the other constituent so-and-so, which is enclosed to the writ petition. And therein, under the heading validity of the said agreement, it is stipulated that the joint venture shall be automatically terminated in case the contract in terms of the said tender was not awarded. This is a fundamental factual difference. If your lordship will kindly peruse our agreement, consortium agreement, which your lordship again will find at volume 5. There it is just the opposite. It has been agreed upon that this is an irrevocable arrangement. It is at page 1679, volume 5 of the volume 5. Volume 5.
There's no volume 5.
We've filed
It
it.
might be in the writ record, maybe.
No, it has been filed separately for
In appeal.
in the writ appeal. It cannot be honest. I had referred to on earlier occasions also. Or else instead of troubling your lordship with just one small clause, your lordship may have a look from.
You read. You read out.
It is the consortium agreement starts at page 1679. The relevant clause is clause 15, which is at page 1683. And this is how it reads. It is further agreed that this MOU shall be irrevocable and shall form an integral part of the contract and shall continue to be enforceable till the purchaser discharges the same. It shall be effected on the date first mentioned above for all purposes. The Honorable Single Judge, instead of relying on the consortium agreement, went by the power of attorney. And this is the fundamental difference, even the judgment that has been relied on by the Honorable Single Judge. That is the factual difference. So therefore, that judgment, firstly, having held that we are a consortium and not a joint venture, a judgment based on joint venture could not have been relied on. And secondly, even in that judgment, there's a fundamental factual difference. So therefore, my lord, we could not have been. And once having held that we can act independently, and the tender clauses making it very clear that all through the burden is put on the lead partner. If your lordship peruses the tender clauses, what it says is only after the contract, in the event of being awarded, we have to arrive at a definitive agreement with the consortium.
Okay.
Therefore, my lord, my humble submission is your lordship will set it aside and send it back for examination on merits. Or else your lordship will take it up on the merits of the issue.
Let's hear the other side. Yes, Mr. Das.
Yes. My lord, we filed this application, IA has been filed. The writ petition is not maintainable because the bidder the consortium who participated, bidder has not come up before this court.
That,
learned
that
friend
prayer
has-
was not accepted.
Now, my learned friend, no, there are two parts in the IA. One part is that bidder itself should have come and challenged this, not come. Second part in the IA, in paragraph 3, is saying 1826, page 1826, paragraph 3 in IA, said two parts. One is that the bidder should have come up before this court. Who participated has not come. Second part is that there is a logistic, the logistic business has been sold on 31/3/2022. So there is a suppression of material facts. So two parts. The learned single that dealt the first part. If the first part could not succeed because he has to stand his own feet, saying that yes, even that particular concept part doesn't come, he can do alone. That is not the case. My lord, my learned friend has read para 39. To what conclusion 39? Your lordship will kindly trouble with para 38 of the judgment. Kindly see at page 98.
Yes.
Page 98 of volume 1, my lord.
Yes.
Now let this court take into consideration clause 3 of the NIT. It would be seen that bidders who meet the criteria stipulated in clause 3.1, 3.2, 3.3 of the NIT shall be qualified for participating in a tender. It has also been mentioned that proposals submitted by bidders who qualify the criteria and laid down shall be technically and commercially evaluated. Admittedly, as could be seen from the proposals so submitted by the consortium of the petition number 1 and respond number 7 through the petition number 1. On 14th of July 2021, it has been mentioned that the petitioner 1 satisfied a technical criteria and mentioned in clause 3.1 having the experience of 450 metric tons as well as having transported generator starter so and so, so and so. It has also been mentioned that petition number 1 satisfied a technical criteria having transport 2 numbers of transformer so and so, thereby meeting the criteria of clause 3.1. It is also apparent from the said communication of petition number 1 further satisfy the financial criteria of clause 3.3d of having working capital of so and so. However, as regarded technical criteria mentioned in clause 3.5.6di is satisfied by performer respond number 7 as it had transported equipment weighing so and so, Haridwar to so and so on point to point. Again, it is performer respond number 7 who has satisfied the commercial criteria of clause 3.2 as it had transported project cargo from so and so to the project site of so and so. The financial criteria mentioned in clause 3.56d, Roman 3, is only satisfied by the performer respond number 7 as it satisfies the complete financial criteria, annual turnover, net worth, working capital in terms of clause 3.3. Therefore, in the opinion of this court, the petition number 1 cannot be said to be an eligible tender alone, but it shall only be eligible to submit a tender provided the respond number 7 credentials are also taken, which would also be evident from MU dated 14/7/2021 itself, where it has been mentioned both the petitioner as well as performer respond number 7 had joined together as a bidder to meet the qualifying requirement of the tender amongst other. At this juncture, it is relevant to take note of the authority incorporating the terms of the condition of the NIT have done so taking into account the requirement. The said authority as per the well-settled principle law is the best person to understand and appreciate this requirement. The criteria was specified in clause 3.1, 3.2 and 3.0 are to be fulfilled by the bidders in order that the bidders bid is technically and commercially evaluated. The petition 1 cannot be said to a bidder or tender alone. It is only when the petitioner 1 joins with the performer respond number 7, then only the said combination consortium can be said to a bidder for the project in question. Now, conclusion on 39, now which my learned friend has read. So one of the matter was dealt, citing one of the judgment of this honorable court. He also has alone come. That particular, the partner has not come, joint venture has not.
The argument is that the judgment is based on the concept of joint venture, whereas the learned single judge has himself held that it is not a joint venture, it's a consortium. So how a judgment dealing with the situation of joint venture would apply to the case at hand? That is what the argument is. On that aspect, remand is sought.
It is not. My joint venture, your lordship, suppose I am in a company. I had the experience.
Yes.
I come out from that company. And now, my lord, I had the experience by my dint of my experience. My lord, I become, because the other one becomes eligible. There's here, my lord, will kindly see the MOU. MOU kindly see at volume 5.
मंगाया क्या भाई? Volumes, where are the
168.
volumes?
I'll just give a copy, my lord. I have
Please do.
two
Please do.
copies.
Why they have not sent it?
What was the name of it?
Yes.
Which same business? 1683.
What do you want to point out?
1683, kindly see the.
1683.
This is MOU
Yes,
at page 1679. What you got it? 1679.
yes.
That's a memorandum of understanding.
Para,
Para, kindly see 1683. Para 5, clause
Hmm.
5. What
that
you
is
got it?
mentioned, that is referred in the judgment,
Yes.
jointly and severally.
Yes, and
responsible.
kindly see 12.
Yes,
The responsible for performing execution of the state contract by each consortium member is as indicated in the annexure 1. It is further agreed by the consortium member that the above sharing of responsibility
Hmm.
and obligation shall not in any way by limitation of joint and several responsible members under this agreement. Now, responsible, now kindly see, my lord. That's at page 1687. 16. This is the works which has to be performed.
Hmm.
Now
So
kindly
they had
see.
already divided it. Responsibility had been divided.
So, my lord, the position, my lord, not only the credits and kindly say division of the work. How can be performed, my lord? How then, my lord, it will by Diaram Shetty, my lord, somebody said we also, but that criteria will be done by somebody else outside. That division of work is there, my lord. That's the whole difficulty. Division of work.
The issue is, Mr. Das, the manner in which the terms have been changed after the
No.
NIT was.
No. I'll just point out.
Hmm.
One, it was 10 years to 15 years, right, my lord? 10 years to 15 years. 15 years, they say now, 15 years has been made for you. Now, let us take for there. If it was not a consortium, it is only that they said that no, we'll make a consortium because they are not eligible.
Original NIT, there was no
And the NIT, my lord, there was no consortium, my lord. Original NIT. Amended and thereafter this
Consortium was allowed later on.
Yes, my lord. So, my lord, here also, the NRL also taken that point, that the logistic has been sold.
All right. Yes.
Now, that is your lordship, just note down, my lord. That is in 1110. My lord, that is volume 4. Kindly say volume 4,
Yes.
1109.
What are you referring to?
Yes, the affidavit of the NRL.
In the writ petition?
Yes. Para 27.
Yes.
Para 27.
Mhm.
That with regard to the statement made in para 14, well, I'll just give a copy, man. That is 1109,
Hmm.
para 27.
Yes. Para 27.
Lordship got it?
Yes.
That with regard to the statements made in para 14 of the writ petition, the answering response state the petition number 1, along with the response number 17 were found to be
All right.
technically
That we have
qualified.
seen. Just first point out that in the original NIT,
I
consortium was not allowed and
Correct.
later on it was brought in.
Yes, I will. I'll point out.
Let's see that.
Now,
first.
kindly see, my lord. Original NIT, my lord, 25/3/2021.
It is in volume.
It will be volume 1.
Yes, volume 1.
Kindly see, my lord, 250. I see volume 1 now. Volume 2, my lord. Volume 1, lordship got it? 255. 258.
Yes.
That's original.
Yes.
This is clause 3.5.6. Lordship got it? The consortium formation shall not be allowed
Okay.
in the original NIT.
Yes.
Now they amended and they brought this. I'll just point out my notes. Now, kindly see 280 of volume, same volume, 280.
Yes, 281.
Yes, 281. 3.5.6. 3.5.6. The consortium formation shall allow subject to meeting condition mentioned below.
Yes, yes.
So this was brought into it, my lord. It is not that.
Yes, Mr. Chaudhary, the concept having participated happily, not challenging the condition beforehand.
Since my friend has taken your lordship into the merit.
I'll just give an answer.
Let him complete.
No, I'll just. My lord, your lordship is very important to note certain dates.
Okay,
This NIT was 25/3/2021, original NIT.
25/3, just,
2021.
just.
Yes.
Twenty-five, 3.
2021, original NIT.
Yes.
Was issued. Pre-bid meeting was held on 9/4/2021.
9/4/21.
2021. Then 12/6/2021, amended NIT issued in the light of discussion of pre-bid and clarification provided at the pre-bid meeting.
That is inclusion of consortium.
That, my lord, inclusion of consortium, 10 years to 15 years, that was all after pre-bid meeting. Now, this is very important date, my lordship, not down. 16/7/2021, technical bid opens and evaluated. Now, my lord, I will kindly note down, my lord. There was no objection. They have not come to the court challenging my technical bid. On 16/7. Now, 24/9/2021.
24/9.
Financial bid opens and evaluated.
Yes.
Now, 29/10/2021.
24/9/21.
Yes, 24/9/2021. Financial bids opened, evaluated. Now on 29/10/2021. 29/9/2021, letter of intent issued in favor of us. Now, my lord, he doesn't come and challenge it also. He comes and challenges.
That is also not challenged.
My May 2022, he files a writ petition before this court. Kindly see, if he was aggrieved by the technical bids, my lord, he could have come earlier. When letter of intent was issued on 29/10/2021, thereafter in May 2022, who has come? Man, it's simple. I am telling you why. I think definitely this logistic has been sold on March 31st March 2022.
Just one.
This is what it appears.
Technical bid was in public domain from 16/7.
Yes.
Now, technical bid was on the public domain on 16/7/2021. It has been sold. They have not come. Maybe they have approached. They say, sorry, we will not come into this picture. This is what has happened. They waited. Only in May 2022, they have filed this petition. When it was moved, my lord, the writ petition, the learned single judge raised a question of an interim order to be protected by this court. This is a public important project is involved. So you alone has come. That's the first point we reached.
Okay.
So this is what, my lord, the factual part. Then, my lord, the contract agreement was executed between us and the NRL on 2/6/2022. 2/6/2022. And 1 second, my lord, I'll show it.
Volume 4.
Volume 4. Distribution of power.
What are you pointing out?
Yes.
1449.
1449, kindly see, my lord.
ये उनका वापस दे दीजिए. 1449.
Yes. This is a power of attorney.
Given by reference number 70.
Yes.
That is what is highlighted in the
Power of attorney which is given by the performer
for
respondent.
filing. For filing.
Yes. No, now what happens? Kindly see 1451. 1451.
Yes.
Third paragraph, kindly see. I'll not trouble with whole third paragraph. The power of attorney shall remain valid until NRL receives a written notice from the company withdrawing this authorization, or NRL communicates, or the company comes to know the tender is not awarded to the company. It's gone, my lord. This is what the learned single judge, I think rightly said that yes, how he can alone can do it.
Yes.
Rule of the game changed afterwards, I could have understood matter. So my humble submission before your lordship is that it should not be interfered. The work is going on, my lord. 30% I have been told by my learned from Calcutta, my lord, the work is going on, at least 30% work is completed. So these are public important project, it would be stalled, my lord. And if they are really aggrieved, they can go before a civil court, file a compensation as NG projects, my lord, it says. This is my submission before your lordship.
Very short rejoinder, madam.
Yes.
My lord, NRM.
NR, yes.
I'm sorry.
Yes.
My learned friend has not gone into the merits, my lord. The lordship will kindly come to paragraph 7 of the judgment, my lord.
Yes.
The fact of the matter is that, my lord, the petitioner alone is not even eligible, both financially and commercially.
Yes, of course, that is a finding. We have seen that. That is what we have seen already.
And
Yes.
that is admitted, my lord, para 7, my lord. Mr. I. Chaudhary, learned senior counsel for the petitioner, submitted to the consortium comprising of the petitioner number 1.
That is why it has been
Is not-
non-suited.
Exactly, madam. Has taken the credentials of the pro forma respondent 7 for fulfilling the commercial criteria, the technical criteria, as well as the financial criteria. So he is not even eligible, my lord. Today, if your lordship even interferes, my lord, can we bifurcate the work now? Because the works are clearly demarcated. There is some construction work which the respondent number 7 was supposed to do. Some work he is supposed to do.
Yes.
The honorable single judge has clearly, my lord, decided those issues. And regarding that finding that we have not said anything, my lord, that my learned senior friend has pointed out at page 1110, our stand is clear, my lord, that he is not eligible now. And so far as tinkering with the terms and conditions of the tender, my lord, that is not correct. It was only in the pre-bid meeting prior to submission of the bids, my lord. And both the parties, the requests of both the parties have been acceded to, my lord.
Okay.
Because he wanted for the experience to be enhanced from 10 to 15 years.
And they wanted a consortium to be allowed.
Not only that, my lord. In the consortium also, there was a criteria that each consortium partner has to fulfill the criteria. That they wrote a letter on 15th of June, my lord. That is on record, my lord.
Volume.
Page, volume.
Both were to be qualified on all aspects.
Hello?
Both were required to be qualified on all aspects.
All aspects, that was changed, my lord.
Oh, just let us see that. That was in the original NIT.
That was in the original NIT.
Let us see.
The original 3.5.6, my lord.
Therein the consortium was not allowed.
Not even allowed.
No. Then the consortiums were allowed. And my lord, each consortium partner was required to fulfill a particular.
Where is that? Where is that condition? Then you relax that also.
Yes, ma'am.
Where is that? Read, please. That is very relevant.
Three point 5.6.
Page, please.
Just give him the page number.
Mr. Das pointed it out. 144. 1451. No.
No, not that one, my lord.
250 is the original 3.5.6. Fresh one is 281.
3.5.6, my lord.
What
Each partner was required to qualify, my lord.
Where is that condition? Let us
Page 1973, my lord.
1973. Okay.
It is volume 6, my lord. It is there in other pages also, my lord.
You are reading the.
I am reading the IM, my lord.
Yes, 1973.
1973. 3.5.6 D, my lord.
Just hold. Yes.
Lordship has got it, my lord.
Either one or both.
One or both the consortium partners shall have to meet.
Yes. So it is either one or both.
My lord. Then he wrote a letter at 1157, my lord.
Just hold on. Yes.
1157 million.
Ah.
It's a letter by him, the 1157. That is in volume 4. That is part of my affidavit. my lord.
1157. Yes. Relaxation of criteria.
May I read, my lord? We would like to bid for the above project in consortium with our group company which meets the commercial criteria, clause so and so of the tender, having order value of so and so crores. However, condition number 3.5.6.D1
Yes.
put by you in tender for the requirement of past experience of multimodal transportation of 450 metric tons in single piece through waterways and roads using so and so for both prime bidder and consortium member will disqualify us and is not in line with many PSU tenders.
Mhm.
And then accordingly, my lord, lordship will kindly come to 1160, my lord. Starts at 1159. This is a corrigendum issued by us.
Mhm.
The original tender is at 1159
Mhm.
and the modified is at 1160, my lord.
Yes.
Since your lordship is taking up volume 4, my lord, just like to point out, my lord, page 1150.
1150.
1150, just few pages back.
Mhm.
This is the pre-bid meeting, my lord, minutes of the pre-bid meeting, because they have projected a case that the private respondent has been favored, my lord.
Mm.
Lordship will kindly turn to page 1152. From 1151, my lord, the various
Just-
suggestions.
Yes. Suggestions at 1152.
1152, my lord, 4G, this is Prism Logistics. 4G, my lord,
Mm.
this is Prism Logistics. What are their suggestions, my lord? Point number 3, willing for consortium can be done for erection company. So these minutes, my lord,
Mm.
were prior to the second NIT.
Second NIT. Mm.
So it is only accepting their suggestions, my lord, we have changed it. So it is not that, my lord, the private respondent has been favored.
Mhm. And now you are saying that this relaxation in this, on the basis of this letter was also allowed.
Yes.
Says that 1160.
1157 and 1160.
1160, read please. Modification,
Modification.
D, 1160D.
1160. Either one or both has been struck off, my lord.
Okay.
Either one of the consortium partners.
Mm. Yes,
Either one of the consortium,
yes.
that is the modification.
One or both has been struck off.
One or both has been struck off. Since it is in black and white, my lord, it is not discernible.
No, it is very clear.
It is one or
One or both
has
has been struck off.
been struck off.
Yes.
And now, my lord, the crux is, my lord, that in a JV, my lord, two parties get together to form a third entity, and that the honorable single judge has held.
Mm.
Now, here they are retaining their individual identities. Now, even this will be even more stricter, my lord. Without any authority from another person,
Mm, mm,
because in a JV, my lord, two parties get together to form a partnership.
mm.
There may be, my lord, if we even apply order 30 of the CPC, my lord, if it come in the name of the JV, maybe one may be eligible. But here it's a consortium and they retain their individuality. They cannot come. There has to be a power of attorney. And in the judgment, my lord, it has been clearly held that the power of attorney and my learned senior friend has shown, my lord,
Mm.
it is no longer valid. Because it says that once the respondent number 7 comes to know that the work has been awarded to someone else, that the power of attorney validity ceases, my lord.
Yes.
And there is no power of attorney authorizing them to institute this case, my lord. That also the honorable single judge has held, my lord. My respectful submission, my lord, no case was made out for any interference.
Okay.
Obliged.
Yes, Mr. Chaudhary.
A very quick rejoinder, madam. While your lordship is on that clause 3.5.6,
Mm.
if your lordship. will
Firstly, your foundation of the case was the conditions have been changed to suit him,
No, no.
which is absolutely incorrect, sir.
No, my lord. There have been deviations in implementing the clauses in the NIT. I had not entered into the merits because the honorable single judge has non-suited us on the issue of maintainability.
Okay.
What I was pointing out was, Malad, they have placed 3.5.6D
Mhm.
without placing the subclause E. Malad. So
Yes.
Lordship will kindly see it is their own terms and conditions. That is what we have been Malad, trying to urge.
Yes, 3.5 point.
3.5.
You just give us one small answer.
What?
Had this fresh NIT not been issued, would you have been able to
No.
even file your bid?
No.
That's
That is
correct.
why we had to. They are saying that we are not eligible. Had we been eligible, we were not required to form a consortium. The consortium
You were
was
not
formed.
eligible on your request. The conditions were changed. Consortium was allowed. Then you requested one or both. You please delete. That was also deleted. And now you come out with an allegation that no, everything has been done to suit one particular, the person who has been selected.
We are not on that. We are on the actual violations, Malad. Those are on merits. If your
Yes.
lordship will kindly come to subclause E for a moment.
First of all, tell us, sir, on the query, you satisfy the court that after having participated, are the violations after the second NIT as per you?
Yes.
Okay.
But that
Now what?
aspect we are giving up completely, Malad. That it has been tailor-made to suit him. Your
Okay.
lordship will first allow me to place subclause E, Malad. 282.
Page
Page 282.
280.
282.
Okay.
This is what their terms of invitation to tender says. Subclause E, the bid shall contain copy of the original memorandum of understanding between the consortium JV members.
Yes.
The MOU shall be converted to a definitive agreement between the parties after award of job and before signing of the contract, which shall be done within 15 days from the date of issuance of the letter of acceptance. So only in the event we get the contract, we are required to convert it into a definitive agreement.
Yes.
And if your lordship will kindly come to subclause I, money. One participating member of the consortium shall be identified as the prime member and has to be an Indian bidder, etc. The prime member shall be authorized to incur liabilities and receive instructions for and on behalf of the partners of the consortium. An entire execution of the contract, including receipt of payments, shall be done exclusively through the prime member. So the tender clauses
That
itself.
is for only execution of the documents.
My
But
lord,
otherwise, you have divided the scope of work amongst yourself.
that I agree. And
Yes.
that is why, my lord.
Then one of those partners who was to undertake major significant part of the work is not coming forward for this litigation. And how you alone can maintain it?
And it's the same partner who, by way of an affidavit, has said that we are with him. It is only so far as the litigation
Why didn't it want to get transport as a petitioner?
for its own business
No,
wisdom.
no.
My lord,
That's not
the
acceptable.
question of law ultimately, my lord, comes down to the same issue.
Consortium and joint venture.
Consortium and joint venture.
We will consider
Having
that.
held that we are a consortium, whether the honorable single judge was right in.
All right, sir, we'll consider that.
Fine.
So you want us to decide your IA or the writ appeal itself?
My lord, your lordship will decide the interim issue.
Why? Now, we have applied our mind to everything.
That, of course, I'll leave it to your lordship. But
All right, arguments have been heard on the IA number so and so, as well as the writ appeal with the consent of learned counsel for the parties. Judgment is reserved.
deeply obliged.
ये लगा देना हो गया. Annex this. Yes. Give the return number.
Item number 9.
Yes.
Well, this is an application for condonation of delay.
Yes.
So only 55 days, 57 days delay, filing the read appeal.
What do you say, madam?
Lordship, I have objection, Lordship, while paying for condonation of delay, so Lordship, the concerned party is required to explain Is the.
That is settled, but the delay is not so significant.
I
But
explained.
Lordship, Lordship, in this case, Lordship, what happened? The judgment was delivered on 20 June 2022. And after obtaining the certified copy of the judgment, the petitioner had applied, had filed representation before the authority on 1st July 2022. And they also give us acknowledgement letter, Lordship. Lordship, I have annexed the translated copy
Yes.
in page number 40.
Mm.
It is in vernacular medium, Lordship.
Yes.
But after perusal of their interlocutory application, they have annexed their certified copy, which would go to show that their intended, not to take their intended application annexer B, page number 50.
Mm.
The same was applied on 24th August. That is months after the limitation period was over, Lordship.
Mm.
So there was
Even certified copy was applied after that.
no, Lordship, they applied.
That's what we are saying. That certified copy was applied after the limitation had expired.
Yes, Lordship.
What do you say, sir?
My letter, I have explained it. Paragraph.
Read, let us see your application. This is a fact. The law is well settled that each day's delay has to be explained.
My lord,
And the matter has only been remanded. Hold a fresh inquiry. What is the
my lord,
problem?
we have received information because cause of action arose outside the jurisdiction of this court, which is in UP, my lord.
Hmm.
Uh,
Was that the objection? Was that an objection?
Yes, we have, after receiving information, we have examined, call for the records and examine it, my lord.
You are trying to raise an argument that the cause of action did not lie with this court to entertain the writ petition, right?
Yes.
Was that an objection before the single bench? And whether that can be a justification,
I'm not.
that can be a justification to condone the delay. Delay has to be condoned on the facts of the case, on the basis of your application. Read the justification, please. Let us see.
I have explained it, my lord.
Yes.
As per,
Read.
5.
Read, please.
The deponent begs to state that after perusal of order dated 26/2020 passed by this honorable single judge in the posted writ petition.
Now, when did you get a certified copy?
etc. The opposite party is petitioner.
What is the limitation? 60 days or 30 days?
My lord, 30 days.
30 days. So when did you get a copy? What is your application? What does your application say about that?
They have signed it by registered.
So you did not even care to get a certified copy. First mistake.
My lord, it was conducted by another advocate.
That can't be an argument, sir.
Yes.
That can't be an argument. Then you prosecute the lawyer before the bar council. Move an application for misconduct. Professional
Not
misconduct.
aware that they have already applied for or not. But because of the,
You are not aware is again not an answer, sir.
because of
Every
the-
day's delay is to be explained. You applied after the limitation period was over.
my lord, because of decision, after the decision, we have applied it, my lord.
After the decision, obviously,
Decision to file an appeal before this honorable.
how can that be? If you didn't have the judgment with you, what did you peruse? You say that after considering the decision
Yeah.
and you took a call to challenge the order.
Yes,
So if you did not even apply it before that, what did you read? What your authorities were having? So as to take the decision.
my lord, only 55 days, 57 days delayed, my lord.
Law says each day's delay.
Because we examine all the papers were available in UP, my lord.
So whether you have mentioned this in your application, where are these facts mentioned in your?
My lord,
Let's see.
it was a higher authority after perusal of.
Oh, UP, Bihar, Rajasthan. Where are those facts mentioned in your application?
Because we have to examine, my lord, all the
So
papers.
you are arguing what is not stated in your application. There is an advice coming from back, fresh affidavit. Counsel for the appellant pays for time to file better particulars in support of the application seeking condonation of delay. Time period for his allowed list of 4 weeks.
Item number 10,
Make it simple. Stipend is higher or lower.
Lordship, contempt petition, my lord, kindly pay to the last order.
Yes, who is there for the education department? Mr. Mazumdar? R. Mazumdar. Yes,
Your Lordship, R. Mazumdar is not present, Your Lordship. R. Mazumdar is not present, Your Lordship.
you are
Um,
appearing.
Yes.
All right.
I can-
Last date statement was made by Leonard AG that the order has been complied with
Partially.
partially. So why not fully?
I've taken stock of- contempt petition.
You are taking instructions or giving directions?
Amount has been sanctioned, my lord. The amount has been sanctioned, my lord. My lord,
Amount has been
sanctioned, my lord.
sanctioned.
Yes, my lord.
So place on record.
Yes, my lord. My lord, give me some time, my lord. I'll produce the sanction order.
A list on next Tuesday as paid by land council. Mr. So-and-so. So ensure someone appears. On the last date only, we exempted personal presence of
Yes,
the secretary.
Armand today, he is not there, my lord. That's right. But I have the information, my lord. The
Okay,
amount has been
okay.
sanctioned. Oblige, lordship.
Next.
item number 11,
Oblige.
May it please your lordship.
13 June. Yes.
My lord, while admitting the writ appeal 167.
Now there's a correction of typographical error.
Well,
Date.
I'm not in a position to say anything. I have not been given a copy of this.
Oh, that's an error on part of the court. IA allowed 24 की जगह 25 कर दीजिएगा June.
Deeply obliged.
item number 12,
Drop teacher matter.
Yes, my lord.
Admit-
Similar cases pending.
admit-
and lordship has
Connect with
passed
so
an
and so
order, yes.
and list before the special bench to be constituted for hearing cases of provincialization.
My lord, actually, my case is pensionary benefit.
It is ultimately
Yes, yes.
arising from the same controversy.
Highly obliged.
item number 13,
Non-payment of contractor fees, my lord, and extended amount, my lord.
Suit lies.
Suit, my lord, there is no dispute, my lord. There is no dispute, my lord. No, my lord, my pair is there, let them make an inquiry.
Why? Why?
No, because, my
What
lord,
we have civil courts, they also want work
no,
for
my
this
lord, that
purpose.
limitation is in over now, my lord. No, my lord,
Limitation, the court has already taken care.
Yes.
All right, we'll specifically observe that the limitation, bar of limitation shall not come in your way.
no, my lord,
Mr. Nath will agree to that.
yes, there are two type of, my lord, sanction. The sanction is not granted by them, administrative approval is there. But
So that
technical
is-
sanction
that-
is not
that
there for
requires-
extended amount.
That requires evidence. And evidence can't be taken in a writ petition.
My lord, that portion, my lord, your lordship, my lord, may I pay that, my lord, if your lordship, my lord, ask them to, my lord, make an inquiry. My lord,
Mr. Nath,
make them
seems
inquiry,
to
my
be
lord.
justified. You see, you got the work done from the man. Now you take a hyper-technical turn that no, we never sanctioned it.
No, they have sanctioned. my
If
lord.
there
No
was an
technical-
officer who did it on his own, take action against him at least. Take your instructions on this. We are not very satisfied. It's a wrongful denial, absolutely.
Lord, I'll take the instruction.
List on 14 June as per.
My lord.
Mr. Nath, prays for time to short opportunity to complete his instructions regarding the prayer made on behalf of the writ appellant in the writ petition and in this appeal.
Lord.
Must.
item number 14,
Lordship, in this case, Lordship, the affidavit filed by us, that which has been annexed, is without the document. Let me bring those documents to record, Lordship.
There's an allegation of false affidavit being filed in the writ pleadings.
That part I will also explain, Lordship.
Mr. Chakravarti prays for and is granted time to
What?
bring on record what?
The documents which we have filed along with our counter affidavit.
Bring on record the relevant documents, some relevant documents, list of 4 weeks.
item number 15,
My lord,
Yes, please.
actually, my lord, the advertisement is of June 1998. The appellant was given first nomination, but my lord, the candidate was given the second nomination was appointed. Then, my lord, I filed a writ petition. Writ petition was allowed. Pursuant to the order of writ petition, my lord, I was appointed.
You
By
are
the
required to clear net slate
Yes, by
within
the
a
time that,
stipulated period.
by the, my lord, the government came up with the first time on January 2000. Whereas my selection was over in December 1998. Even the, my lord, the UGC guideline also which prescribed net and slate, that was issued on 24/12/98.
98.
8.
Where is this argument dealt with?
Yes. My lord will kindly come to page number 134.
Para 7.
No, my lord, 14.
Para 14.
The issues were framed, my lord.
Yes.
Then my lord will kindly come to 135. The point number 1 and 2 are taken up together. The learned standing council for the higher education department has produced a copy of the UGC notification dated 19/9/91. The said notification has been issued in exercise of the power conferred by clause E of subsection 1 of section 26, read with section 14 of the UGC Act. The said notification has superseded previous notifications dated so and so. In schedule 1, thereto the following qualification is prescribed in respect of the post of lecturer. Perhaps, my lord, the learned single judge relied upon the first para. Candidates besides fulfilling the above qualifications should have cleared eligibility test for lecturer conducted by UGC CSR for similar tests. In the notification dated 19/9/91, clause 2 contains a non-obstantive provision to the fact that no person shall be appointed to a teaching post in university or in an institution, including constituent or affiliated colleges, recognized under clause F of section 2 of the UGC Act. Moreover, under clause 11 of the notification dated 17/6/87, issued by the Government of India Minister of Human Resource Development, Department of Education also prescribed to the effect that only those candidates who, besides fulfilling minimum academic qualification prescribed for the post of lecturer, have qualified a comprehensive test to be specifically conducted for the purpose will be eligible for the appointment of lecturer. Therefore, in the light of the content of the said to notification, the court is unable to accept that the petitioner would be entitled to whichever the qualification requiring clearing of eligibility test of lecturer. There is no dispute that net slate is such eligibility test prescribed to be cleared for appointment to the post of lecturer. Similar condition requiring, let's say, retard amongst others in the subsequent UGC regulation on revision of pay scale, minimum, etc. From the contents of OM, this is the OM, my lord, which for the first time prescribed.
It's all right, but the OMs were earlier
No, my lord.
existing, already prevailing.
No, my lord, there was a requirement of ratifying. My lord, until the law in Kalyani Mativanan, my lord, this UGC regulation, unless it, but this government stand of the state government in so many cases before these honorable courts. They have to, adopt it. They never adopted. They adopted for the first time on 13/1/2000. My lord, if that is the stand, then my lord, after 13, why I was not paid, my lord? I was working for 8,000 rupees.
Yes.
And my lord, I filed an RTA application, my lord, seeking information as to whether the other persons who applied for their person to the advertisement of June 1998, they are required to, they had net slate. The answer is no. My lord, but for that wrongdoing by the college, my lord, I would have been appointed. This requirement would not have come. Now, my lord, this 91 was never adopted by the state. For the first time on 31, in the affidavit filed by the state before, kindly see, my lord, in the affidavit, compilation.
Come to para 31 of the order.
My lord. Para 31, my lord.
Yes.
Yes. Delay, my lord.
No.
Therefore, the point of determination number 4 is answered by holding that having accepted her appointment dated 21/1/2006 and approval letter dated without any demur, the petitioner by application of principle of estoppel, the petitioner is estopped from assailing the conditions contained therein. My lord will kindly appreciate a person who was given first nomination was never appointed.
Mhm.
Then, my lord, after a long legal battle, I got an appointment. It's very difficult to get an employment. Kindly see my condition, my lord. What else do I do? What else I do, my lord? Is it a case where, my lord, that estoppel should be?
Admission notice.
My
You represent all respondents?
Lordship, lordship.
All, are you
Yeah,
sure?
I'm representing lordship 1, 2 and 3 lordship.
Your good name, please?
Yeah, Google lordship.
Mr. Gogoi appears for the response numbers
1,
1, 2 and 3.
lordship, lordship.
Thus, steps for service on the respond number 4 and 5 be taken within. You could have fared better, Mr. Chaudhary, by implementing the UGC. Things would have become much more clear. It would have been a better way to do things. Anyhow, response number 4 and 5 be taken within 3 days, whereupon process be issued to such respondent.
The 3-4 prayers,
Hmm.
comprehensive prayers submitted by me as the council, and therefore we come to you, lordship.
Yes, please, carry on.
My 3-4 prayers is
Yes.
in Annexure 2.
Mr. Das,
Yes, ma'am.
what kind of proceeding is this? No acquisition, talks on the table with
He
whom?
doesn't have a right, my lord. That's the whole.
There are 3 sets of
three
appellants.
sets of writ petition which.
The
were
one
filed.
those who don't have any title documents.
But they doesn't have any title documents.
This is the writ petition, writ appeal number 10.
Writ
What
appeal-
about 13 and 14?
My lord, one.
That is an
writ petition-
admitted case.
This is, there are 3 writ petition.
3
One
writ
writ
appeals.
petition 140 of 2019. That writ petition, my lord, they didn't have any permit or LEC in respect of that admitted position. Now, the second writ petition,
Petition 91.
right, 91 they have,
Yes.
they
So
have.
it's your admitted case.
No,
We
that-
did not resort to any kind of
My
acquisition.
lord, that, but other 2 writ petition, my lord, let me put honestly, they doesn't have right. But 91, yes. They issued under the new Act 2030. But not these 2, my lord.
It's been under 1894.
Because
Acquisition of 2010.
acquisition of 2010,
So under the Act of 1894,
yes.
you didn't do anything at all.
That's right. No, they will. Higher compensation, yes. So far as one matter is concerned,
Mm.
not for the other 2 matters, my lord. Other 2 matters, we paid them. For whatever crops or building which they have raised, we paid them.
Mm.
One matter, yes, my lord, under the old Act 1894,
Yes.
which was not done.
It was acquired as a cluster.
What do you say, sir? In 2 cases, your clients do not have any kind of title documents on the land. So what kind of proceedings do you expect?
My lord. my
Yes.
lord, My submission is this.
Yes.
As a statutory body, they should follow the statutory law. And first of all, issue a notification under section 4 of 1894.
They were using government lands. Why are they required to issue that notification? If the document, if the lands are simply occupied by encroachers, are they required to acquire them
We are
as
not,
per 1894?
we are not encroachers. We have been.
You don't have any documents. That's an admitted position. You don't dispute the fact. In two of your appeals, the litigants concerned don't have any title, any pass for the land in question. Do you dispute?
For that, we don't claim the value of the land.
Yes.
We are claiming for the value of our properties destroyed or taken.
So they have already been given that compensation.
No, that cannot be compensation, lordship. My lord, that cannot be compensation. That should be compensation only if notification is issued, if due process is followed, and under.
Mr. Das,
lord,
it's
they-
not the owner,
No,
it's the occupier also.
They agreed to it. Agreement was it. No, kindly see.
That
judgment.
agreement was under pressure,
No, kindly see-
unconscionable contract.
Kindly see para 14 of the judgment.
Can you undertake such an exercise without a notification, please?
So once they accepted, my lord, I do agree. my lord,
That
one.
you are putting the horse before the cart now.
No, no, they didn't have any title.
Maybe so,
didn't have a
occupied, the word uses
No, my lord, they
occupied.
didn't- I can be, my lord, somebody can be, but crops they have been played, building that have been.
Oh,
paid to them.
gentlemen, question is, paid under what law?
My lord,
That exercise had to be undertaken by 1894 Act.
my lord, you kindly see para 14 over there.
We have read the entire judgment, sir.
Yes, para
He
14.
proceeds on the premise that his compensation has been paid. To whom? There had to be a notification, there had to be objections. That was as per law. Otherwise, you can pay to anyone under the sky. What is the verification of your actions?
But then I'll produce the records before the court. Records, how it has been done, agreements, all.
All right, then.
You know, look, I am also conscious, my lord. I know, my lord. If they are entitled, they should be paid. So let me see the records.
Mr. Das, question here is, can the state acquire land without resorting to the provision of law?
In one of the case, yes, it should be under 1894. Let me see the records. I have not seen the records, my lord. What is in the
You
record?
are arguing before
What are
single
the
bench.
agreements? I have not seen that.
All right, get the record then.
Yes, we'll get the record.
Issue notice, Mr. Das, Chairman Council, Mr. Das appears for the state of Nagaland,
Mizoram.
Mizoram, Union of India. Notice we issued to the respondent number 1. One and thereafter, who more? For the other respondents? Apparently, it is high-ended. Steps of service on the remaining respondents. Das will appear for response number 6, 4, 5, and 6.
Yes.
Steps for service on the response numbers 1, 2, and 3 be taken within 3 days, whereupon process be issued to such respondents. Rule is made returnable in 6 weeks.
Yeah.
Executing agency was NHIDCL. No, GREF.
Yes.
Okay. Rule is made returnable in 6 weeks.
My lord, can be given a date after 6 weeks, a date,
Give a date after 6 weeks. 21st July.
31st July. And my lord, please admit the case. Admit the cases.
We have issued notice first.
And
You file this requisites and then notices will be issued to the other 3 respondents.
and same is the case with,
Yes, items number 21 and 22.
yes,
We issue notices in all 3.
yes, lordship.
Okay.
Thank you, my lord.
Briefly.
Item number 23.
23 to 27, those matters when education matter.
These are education matters.
Old pension scheme.
Old pension scheme, drop teachers.
No. This is old pension scheme. They were appointed in the year 2002.
This is nothing to do with provincialization.
Nothing to do with.
Same matter, my lord.
No, nothing to do with provincialization. There is one case your lordship has admitted. Relatable 163, 2020. This is old pension scheme matter.
It's only relating to old pensions.
Old pensions.
Not, they are claiming regularization from a backdate. Effect of regularization from a backdate.
Yes, absolutely.
So that is what the prayer admit issue notice. Respondents.
Relatable 163, 23, madam.
Hmm?
Relatables 163.
These are items number 23, 24, 25,
26.
26 and 27.
Yes, madam.
Respondents are duly represented by Mr. Katnia. Sufficient copies of the writ appeal be provided to him. Notice is need, the service is complete. Connect with so and so.
Mr. Naik.
You will also be appearing?
Finance department.
Mr. Naik for the finance. Mr. Naik.
Relatable 163, 22.
Connect list with so and so.
And we need not take any steps. Because
Need not. Just providing copies will.
Yes.
Item number 28.
Please, my lord, by this repeal, I challenge the order dated 17/3/2023, my lord, page 96, whereby dismiss the petition, my lord. The matter pertains to appointment of compassionate appointment, my lord. And my lord, in pursuance of the scheme, my lord, office notification, my lord, the condition has been placed before the DLC, my lord, district level committee, my lord, in 3 times, my lord. And The ultimately, my lord, the rejected stating that, my lord, the 2 years has been elapsed, my lord, due to, my lord, want of vacancy, my lord. But in pursuance of the scheme, my lord, clause number 15, there is a provision, my lord.
The
If
question here is, sir, is appointment on compassionate ground a right? You survived for 2 years to obtain the degree of B.Ed, and now you say that now you consider me. Is it a perennial right which continues?
due
The
to-
concept of penury
my lord,
and tiding over financial distress, this is totally contrary to that.
but,
So how can you claim beyond that?
my lord, due to fault of the respondent, my lord. Fault of the respondent.
You claimed appointment as a teacher, you are not qualified.
My lord.
So why you are required to be considered?
My
You
lord,
could have claimed for grade 4, they would have considered.
my lord, in the, my lord, earlier judgment, but order of this honorable court, my lord. Thereafter, my lord, it rejected, my lord. Thereafter, my lord.
Gentlemen, that's what we are saying. The DLC has not closed the door. That doesn't mean that your right would continue unabatedly for years together, waiting for you to acquire the degree, qualification, and now offering you the compassionate appointment, as if it is a right. What kind of indulgence is that? Tell us one judgment wherein the court can say that no, all right, wait for the candidate to acquire the degree and then grant him compassionate appointment as if it is largesse. Show us one judgment.
But in clause number 15, my lord, office memorandum, my lord.
Yes.
That it is that there is a specific provision, my lord. If any no vacancy available in the concerned district, concerned
It's
department.
not a case of vacancy. It's a case of you not having the qualification. Initial stage, that was the situation.
My lord.
So you're not qualified, you're not qualified.
Then, my lord,
You should have claimed, you should have applied for a lower post for which you are qualified. You straight up wanted to join as a teacher without having qualification. Is it right?
Thereafter, my lord, the kindly see, my lord, order of this honorable court, my lord.
Yes.
Is page 43, my lord.
Now that is a wrong order, we say. We'll say that it
Page
is
75, my lord.
absolutely unwarranted.
This honorable directed, my lord, where he is eligible, my lord.
It can't be, sir. That's very,
Page
again, the very
75.
concept of compassionate appointment is violated by this direction.
Page 75, my lord.
Yes, read.
40 portion, my lord. The petitioner is now willing to accept any post for which he is presently qualified and therefore.
Yes. So did you move any application that please appoint me against any post for which I am qualified? Did you move such application? Hmm.
And thereafter, my lord, that place, candidates placed before the DLC stating that, my lord, no vacancy available, my lord.
Oh, Mr. Counsel, we are asking you, single bench said that petitioner is willing to accept any post
My
for
lord.
which he is presently qualified.
My
Did you move any such application
No, my
that
lord,
consider me against grade 4 post?
my lord.
Did you file an application?
No, my lord, but as because, my lord, there is a bar, my lord, there is a bar, my lord, the application should have been applied within 1 year from the date of the deceased employee, my lord.
Yes.
But I initially applied.
Applied
within
for
1
a
year.
teacher, knowing very well that you are not qualified.
And
So
clause,
that application ought to have been rejected then and there.
clause 15 of the office memorandum, my lord,
Yes.
said that if not available.
If post is not available, is not a question of post. It's a question of you not being qualified.
My lord, in any other department, I am being qualified, my lord.
As a teacher, where is your application?
My lord, kindly. Yes, 58, my lord.
Let's see. Yes.
My lord, as an assistant of any ME school as per government scheme and guidelines.
Yes. So you said that appoint me as an assistant teacher.
My
You
lord.
did not make any other prayer. So why you were required to be considered for any other post? You were very categoric in your prayer. And for that you were not qualified. No dispute.
My lord.
Why your candidature was to be considered.
Clause 15 of the office member.
Yeah, let us see.
My lord.
Yes.
You stated, my lord, kindly see, my lord, for a moment, my lord, office memorandum.
Yes.
page number 87, my lord. If sufficient vacancies are not available in any particular office.
It's not a case of vacancy. Why your application was rejected? Where is the order?
My lord. VLC rejected, my lord.
Page
Page 61,
60?
61, 61.
First VLC rejected, my lord.
61.
Yes.
61.
Yes. Read, please.
And 11%, page 68.
Yes.
DLC discussed an application following applicant, but could not be recommended as the education quality upper teacher required B.Ed degree, which is mandatory for.
So it
upper-
is not for the reason that there was no post. The rejection was because you are not qualified for the post you demanded.
My lord.
So there is no question of going beyond that.
And
You never modified your prayer. You could have mentioned in your application or any other post for which I am qualified. But you are categorical.
There is a single judge of this honorable court passed order, my lord.
Yes.
Direction, my lord. Kindly see, my lord.
Yes.
Page 75, my lord.
Yes.
The petition is now willing to accept any post. Page 75, my lord. Which is presently qualified and therefore respondent are directed to consider the case of the petitioner for appointment on compassionate ground to any post for which he is eligible.
Yes.
Accordingly, case of the petitioner shall be placed before consideration in the meeting of the DLC within a period of 4
So
months from today.
this direction we feel is totally not justified. We are not going to ratify this decision by any means. Because this means giving perpetuity to the right or a stake for claim of compassionate appointment. As and when on whatever post available, that can't be done. There are other people in queue. Why should you be allowed to join or get the post to which some other deserving candidate would be entitled?
But if the respondent.
What has been done in this direction, in pursuance of this direction?
They have placed before two DLCs, lordship, in the year 2020 and in the year 2021.
Yes.
In both the DLCs, they were rejected on the ground that want to vacancy, lordship.
All right. It can't be indefinitely continued. Yes.
No, no. But if the respondent would.
This is not a right.
Follow the office memorandum from the initial clause 15.
Yes.
Then the petitioner would have been.
Your client was ill-advised, sir, at the inception. He should have applied for grade 4 post or grade 3 post. If so, it was not fit, but he wanted to get in as a teacher. That is the problem. Dismissed.
Obliged.
My lord, last focus and delay has been condoned, my lord. They are supposed to supply us my lord.
Copy of the writ appeal.
Yes, my lord.
Provide a copy of the writ appeal. Concept of the plan to provide copy of the writ appeal to Land Council representing the respondents who prays for and is granted 4 weeks time to complete his instructions. List up 4 weeks.
May I please one? My lord, the provisions of the Assam Education Provincialization of Services, Teachers and Education Institution Act 2017 is under challenge. We are regularized as tutors, my lord, whereas we are claiming as teachers. My lord, similar matters, my lord, had already admitted, and those were, my lord, in that list for hearing. It can come together, my lord.
Admission notice list before the special bench to be constituted for considering matters pertaining to provincialization.
Lordship, much obliged.
Malab, this is also regarding to non-teaching staff. Similar matters are admitted, Malab, were challenging the virus of the act. So lots of love to tag with the other matters, Malab.
Same. admit issue notice.
Connected matter with number.
Copies, Mr. So-and-so appears, Mr. Katniar and Mr. Naik appear for the respondents. Sufficient copies of the petitions be provided to both learned counsel representing the respondents. List before the special bench to be constituted for hearing matters arising out of the issues of provincialization. Deep level.
Item 32.
Service completion. My lord, the service in those matters are complete. The issue was, my lord, surfacey proceedings initiated against me by the bank. My lord, there was a fraud played on the bank by the borrower. He was a builder, he and his wife together, my lord, by way of an agreement of sale. My lord, the plot that was already sold to me, mutated in my name, husband and wife together, my lord, made an agreement for sale to the husband. That agreement for sale was given to the bank and a loan was obtained, my lord.
Okay.
The loan not being repaid, my lord, the bank, my lord, issued a notice to me. I came up before my lord. I told that my property, there cannot be any security interest created on basis of a, my lord, agreement. There has to be a sale deed, my lord.
Only on agreement.
Only on agreement there. That's why the bank is also not appearing, my lord. My lord can have that, my lord, at page, my lord, page 42, my lord.
Who is the standing counsel for UCO Bank? Is there any standing counsel?
Name has been shown, my lord. UCO Bank, SCA UCO Bank has been shown.
Agreement. This was
on the
There's
basis
security.
of this, my lord would say this is the wife who is making that as a director, and the husband, my lord, is buying it, agreement to sale.
No.
And my lord, he expired. So we substituted the wife also. Notices were served. Still late, my lord, nobody has come.
All right.
I am neither borrower nor guarantor, my lord.
Proceedings of taken under the Securitization Act on the assets of the petitioner are challenged on the ground that the petitioner is neither the borrower nor the guarantor towards the loan taken by the respondent number 5. It is contended that the loan was sanctioned on the basis of a forged document.
On basis of a deed.
On the basis of a deed of agreement, which does not confer any title.
Right.
It is further contended that, as a matter of fact, the plot of land owned by the petitioner was transferred through a fabricated sale deed.
No, my lord, but that sale deed was originally given to me. And thereafter, on the basis of the same flat, my lord, they made an agreement for sale, husband and wife.
The flat in question is owned by the petitioner.
Lordship.
However, the respondent number 5 created a fabricated deed of agreement in relation to the same flat, kept the same as mortgage with the bank and obtained the loan in question. No one has appeared on behalf of the respondents despite service of notices in this writ petition. Hence, there is wakalatnama on behalf of 123. Though wakalatnama has been filed on behalf of the respondents number 123.
And the name has been shown, my lord.
No one is appearing. No one appears on behalf of such respondent. Thus, the writ petition is admitted. Admit issue notice.
What? Interim order.
What is the interim order?
My lord, that proceedings have been stayed, man.
Add interim order dated. So that must be in the IA.
I know, my lord, that was in the WPC 23/2019, my lord.
Add interim order dated
23/2019.
20th March 2019 is confirmed to last till disposal of the petition. Steps for service be taken within 7 days.
Lordship.
Fresh steps for service. Lordship. Manager must be.
Item number 35.
May I please, your lordship?
Yes.
Your Lordship, in this matter, we have filed an affidavit yesterday, Your Lordship, and the same is not on record.
What is the affidavit about, madam?
Your Lordship, this is a PI regarding the corruption that took place in the 4 districts of the BTC area, Your Lordship.
All right, Council MS. Your good name, please.
And Mahanta.
And Manta states that she has filed affidavit on behalf of the petitioners yesterday. Same be brought on record. The matter will be listed in July.
Deeply obliged, Your Lordship.
Item number 36.
But the last order, Lordship directed the revenue officer to be present before the court part and police the original records, my lord. As the original records in the vernacular, my lord, I'm policing the original records also.
Vernacular will not be able to read, Miss.
My lord, that honorable justice, my lord, may read it, my lord. I have translated, my lord, English version is there.
Okay. Can you provide a copy to the petitioners council, please? Then we can take the matter at 2. We'll take the matter at 2 then.
My lord.
Okay. We have a look at the record.
My lord.
Show the original record to
He
him.
may look at the original records.
Yes, please show it to him at 2.
Obliged.
Fast.
Item number 39.
Lordship direction, we have filed affidavit. My brother has also filed a reply, Lordship. It relates to the education man, special education man's matter, Lordship. This matter relates to the special education man, provincialization he is seeking, Lordship.
Provincialization.
Lordship.
I'm agreed by the the non-incorporation of this provision for provincialization of the venture department of a provincialized college.
So ultimately, the issue raised in this petition arises from provincialization of teachers. Thus, the writ petition is admitted. Pleadings are complete. Place before the special bench.
Obliged.
Item number 40.
This is regarding illegal detention of the petitioner's relatives. The last occasion, your lordship was pleased to direct the respondent to file affidavit.
Yes.
But we have not received any affidavit.
Madam, we are in the process of filing. It will take another half an hour. Maybe.
2 o'clock. Come at 2.
Madam, may I suggest one thing, madam? Lordship, we kindly have a look at the prayer question at page 14.
1-4.
Madam,
Yes.
the first part is about, they say that produce the victims. And the prayer B is, madam, why a writ of mandamus should not be issued.
Compensation.
Compensation. And so far as first part is.
Yes,
concerned,
of
madam,
course, now.
it has become redundant. Second part, madam, we are filing the affidavit. They would like to file a reply to that. Lordship will hear the party matter, madam. Let us not.
Let's have a look at the affidavit.
Now, first part is not redundant because two petitioners, two relatives, the first wife and the brother of the suspected accused have been forwarded on 31st. Lordship has already observed. So that is not the because you picked up 20
They are arrested, madam.
and
They were
arrested on 31st.
Arrested on 31st.
Yes.
There's a 4 days clear period of illegal detention.
Madam,
Absolutely clear.
file the affidavit, madam. They were released. on-
Don't use a strong arm on ladies and children, mister. You have not become such spineless creatures. Have your police officers become so spineless that they have to look at ladies and children for that?
Madam, children were not, Lordship will kindly bear with it. Children
Mr.
were-
Mazumdar, we are not accepting your argument.
Madam, Lordship
The
will kindly-
facts are starkly visible.
Madam, Lordship will kindly bear with me. Children.
Come back at 2, we'll see. They just tagged along like annexures.
And there was nobody to look after. One was my breastfeeding.
What was such an urgency with your officers that the lady had to be picked up at 4:30 in the morning?
And the lady.
We'll see and I'll come back at 2.
Madam.
Even the 10 years boy was also tortured physically in the police station.
No, this is absolutely incorrect, madam. This is absolutely incorrect.
We'll see.
Absolutely
Come at
incorrect.
2. Come at 2.
Item 41.
Yes,
Lordship,
the order.
appellant is appointed as.
Yes, what do you say, sir?
Let to have been appointed, my lord.
Then what survives?
Lordship.
Hmm?
Lordship.
All right. Then Councillor Ms. Bora has placed on.
My lord, so far as my lord, the appeal is concerned, my lord, the appeal has not been disclosed. I have not been given any hearing. My lord. I am the private.
So you challenge that order if you want.
My lord, because since the lordship stayed, my lord, the order, therefore this appointment has been made. By which, my lord, the appointment, my lord.
The order is not because of
Because the entry
this
was-
stay order. No, order doesn't say.
Doesn't say so, my lord, but then.
Yes.
No appeal hearing has been conducted, my lord. Let them, my lord.
All right, you argue the appeal, we'll admit it then. All right, the appellant and Councillor Ms. Bora has placed on record copy of the order dated 26/4/23, which as per by effect whereof, the appellant has been
Serial number 3, my lord.
appointed as Gaon Pradhan of in Gaon Pradhan, Gram Panchayat Bagbar,
Lordship. Charge
Bagbar.
number 17, my lord.
charge number 17. Post up. The order is taken on record. For academic purposes, the writ petition, writ appeal is admitted. The ad interim order dated so and so is. But this is by virtue of decision of the appeals, gentlemen. So
No, but appeal, no hearing was given to me, my lord. That's the difficulty.
that is a different cause of action to you. You go and file that, challenge that appeal, the appellate order.
Since the appeal was sent, my lord, they have to have given me hearing, my lord. That's the
Oh,
only difficulty.
that is, again, you charge fresh round of fees from your client, approach the court. Then we'll close these proceedings. Since the appointment of the appellant as Gaon Pradhan is in pursuance of the decision on the appeal of the respondent number 1 writ petitioner. Appeal was by the respondent number 1.
Yes.
Lordship.
No, appeal was by the petition.
No.
That's petition.
Madam, this doesn't refer to the appeal. Madam Bora,
Lordship,
this doesn't refer to the appeal. So then admit this writ appeal. The writ appeal is admitted and interim stay order is confirmed. Last disposal of the list for hearing in due course.
Obliged.
Item number 42.
Yes.
Lordship, this appeal is directed against the order dated 1/6/18. Passed in the Aizal bench, Lordship. You will
Yes.
find the order at page 41,
41.
page 41.
Just one. Yes.
Now, Lordship, the issue here is payment of rental compensation.
Okay.
What has happened here is, Lordship, the armed forces are in occupation of 34.704 acres of land, out of which, Lordship, 27.713 acres of land is government land. So for the rest of the land, we have to pay the rental compensation, and which we have paid.
You already paid.
Which we have paid. Now the dispute arises, the petitioners hearing. They claim that their land was also occupied. And this falls within the area of 34.704 acres.
Okay.
Now the question is, Lordship, if 27.713 acres was private land,
Government land.
was government land, the remaining private land, we have already paid for that. Now from where these new petitioners creep up? The only explanation that the authorities have given is perhaps they were not included in the earlier survey made, but they are within that 37 point some land.
Okay.
If they are within 37 point some land,
Then you already paid the compensation.
we
as
have
per
paid the compensation.
it. Okay.
Now,
And since this dispute has been going on, Lordship, if I may submit, Lordship, land rental in Mizoram and Arunachal, Lordship, it is a perennial problem like going on. And since we have paid like every day, if a new petitioner creeps up, it becomes very difficult for us. And in fact, Lordship, this issue has been taken up, of course, after this order has been passed with the Chief Secretary, which I have brought to the notice of the court by my affidavit filed on 18/11/19.
Okay.
At page 80 of that affidavit. If I may take your lordship to page 80.
Mr. Chaudhary,
My lord.
if you read para 16 of the order,
Lordship.
what do you say about that?
Yes, lordship, that is what.
So that is the joint verification report prepared by your officers.
That's the thing.
So how do you get out of that? How do you argue contrary to that? So maybe for a,
Lordship will kindly see.
yes,
The joint verification report and the affidavit submitted by the central government and the state government clearly point to the fact that the petitioners' land are within the area occupied by the armed forces. No, what I was submitting, lordship, that private land, if they are lordship, these people are private landholders, lordship, that would have reflected in the survey. Private land, we have already paid, lordship.
that survey was found faulty by the learned single judge.
That
Para 6,
lordship, that
para 6 read, how do you satisfy the court that these findings are not correct?
from the materials available on record, more particularly the joint spot verification dated 15/16/11, it is apparent that there is no dispute as regard the entitlement of the petitioners to receive compensation on the aforesaid account. Dispute, if any, is pertaining to the question whether the amount of compensation already disbursed. Now, if they are lordship private landholders within that patch of land of the private, we have already paid. Now, whether it has been disbursed.
You are reading at which para?
That lordship is at page 4.
Para 6 of the judgment.
Page 51.
Assessment of rental charges.
Yes. The assessment of rental charges for occupation of the land of the petitioners by the armed forces was assessed by the respondent number 6 for 3 periods, so and so. Insofar as assessment for the first and the last period is concerned, the same as are already satisfied by the Ministry of Home and State Government respectively. For the second period, the occupation under the Ministry of Defense, the amount assessed was 5350. It is for this period that the petitioners have made their claims along with the interest for delayed payment. It is a contention of the respondent number 1 and 2 that they have paid the rental compensation for the area of the land covered by the blueprint sketch map. Blueprint sketch map is the whole area covering an area of 6.991 acres. However, the joint verification conducted on 15/11/2011 came to the finding that the land of the petitioners actually fell within the area covered by the blueprint.
So that means you paid compensation to someone who was not entitled.
Exactly. No, lordship, what we have done, we have not paid it individually.
You have given it to the state.
Yes, lordship, they have to
So the
distribute.
dispersal is wrong as per you.
That may be, lordship, that may be their case. That may be.
What has the state said on this state?
State
the
lordship
state
in the affidavit, they say, if I may take lordship to the state affidavit,
A variation in area is not too much.
is not too much, is not too much.
So only issue is whether the land rent was paid to the actual claimants. So that would be in between the state and the claimants. Yes.
Because from our side, we have given the amount, like if any other party has got the payment, that lordship we cannot say. If I may take your lordship to the page 67 of the memo of appeal.
Yes. 67.
And
Just a moment. Where is the writ petition? 67.
67, the affidavit filed by the
State.
state government lordship.
Yes.
If I may take your lordship to paragraph 268, that the 1992-93 board meetings recorded that the total area under the occupation of the army at so and so is 34.704 acres. That out of the total area, 27.713 acres was government free land, and the area of 6.99 acres belong to the private lands for which rental has to be paid. The joint verification report was conducted on 15/11/11, and the report shows that the land of the present petitioners with an area of 4067.5 square.
Mr. Kalita, they are very clear. They have made the disbursed payment. How you distribute, that is your problem. Why they are required to pay it again and again? Why direction to the response numbers 1 and 2?
These people will not pay. These people will not pay.
You represent whom?
State.
So state has not paid. The union has paid to you.
My lord, actually what had happened, we were excluded from the payment on the ground that the land belongs, is a government land.
No.
Please come to page 51 for.
No. You see 6.99 is identified as private land.
Yes.
You claim that your land is a part of that 6.99.
Yes, and joint verification has revealed that.
They have paid for the entire 34. Say 34 they need not have. They have paid for the entire 6.99. That has been given to the state. Now, how the state distributes, why direction, additional direction?
One aspect, Lordship will kindly come to page 51 for a moment.
Yes.
Now, towards the bottom, my lord, sentence starting with however, the joint verification conducted on.
Ms. Chaudhary, this is basically flawed for the reason that the defense is not required to make payment to any individual petitioner.
No, that's correct.
They passed on the entire compensation amount
No, my lord,
to the state.
Stand of the authority was
Yes.
that this is a government land. Kindly see, my lord, last sentence.
No.
Appears to have been excluded the land of the petitioners by considering the land to be government land.
Ms. Chaudhary, overall scenario, you will see
Yes.
the private land is 6.99, not
Yes.
beyond that. And for 6.99, they have paid the compensation. That is very clear. So how the state distributes, that is their headache. Why direction is to be given to the union for that purpose.
No, my lord, the stand of the defense ministry before the learned single judge was, they are not required to pay because that's a government land. It is only that.
No, sir. Please,
Yes,
please come to page for para 14.
para 4, my lord.
Para 14.
Okay. Yes. Says so-and-so counsel for the submits that the 92-93 broad proceedings recorded that the total area under occupation of army was the 34 point so-and-so acre. Out of the total area, 27.7 acre of land was government free land, and that an area of 6.99 acre belonged to private landowner for which rent has to be paid. That a joint verification was conducted on so-and-so, and report showed the land of the present petitioners with an area of so-and-so fell within the blueprint. That although DEO had stated that the rent for the private land holdings in so-and-so area was paid in 3 phases for so-and-so, 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 the actual pay receipt of the 3-phase payment and record of DEO did not tally.
So that is the problem of the state government. Disbursing authority, they have paid for 6.99. They are not required to pay for anything beyond that. The
No, my lord,
blueprint also says
my lord,
6.9.
as far as we are concerned, my lord,
Yes.
we are entitled to the
So,
rental
but the relief
compensation.
was not granted against the state. Problem here is you are required to challenge that order. That direction be given. The direction to the Union of India is not totally unjustified. You will have to file a fresh writ petition actually, alleging that the state has made a wrong dispersal. You can take your time and rethink.
Let me, I mean, have the instructions also, my.
Yes, and Mr. Chaudhary, please for. and is granted. Mr. K. Chaudhary, senior advocate representing the private respondents, praise for and is granted.
2 weeks time.
2 weeks time to complete his instructions. Is there a stay on the order?
No. Yes, and give more.
State is not made a party. We have been only asked to an activity that is not right.
Lordship, I may, because this is before my time, Lordship.
Oh, no, you don't raise that argument. In the meantime, Mr. R.K.D. Chaudhary, Deputy SGS shall implead the state of Mizoram and they respond as well as the response numbers, state of Mizoram, secretary so and so, director so and so, and deputy commissioner so and so,
I will do that.
as party respondents in there.
Lordship, I will do that.
Since Mr. Kalita already represents the state, formal notices will not be required to be issued. List of 4 weeks.
Item number 43.
Lordship, in the
Yes.
last occasion, Lordship, I was allowed to be an intervener. Lordship, I want to put my stand on record. Lordship permits.
Will you do that?
File a short affidavit. I'll file a short affidavit.
And counsel appearing for the intervener. Praise for and is granted 2 weeks time to file affidavit on behalf of such. On their behalf, on its behalf condition. 2 weeks, list of 2 weeks.
My lord, at least some protection will be granted because state government report says that they have found positive formaldehyde content in the.
Madam,
Lordship,
what
we
steps have you
already
taken?
Lordship, we already have filed the affidavit, Lordship,
Mm.
and one affidavit filed by the Lordship. Respondent number 2 is
Mm.
the Commissioner of State Public Health Laboratory, Lordship of the. They have stated that some anomalies have been found, Lordship, that the way the test has been carried out. Lordship.
And Lordship.
And thereafter, Lordship, the government also has filed an affidavit where Lordship for cross verification, Lordship, they already have issued communications to the Guwahati University, Dibrugarh University, then College of Fisheries, Roha, then College of Veterinary Science and Central Indian Fisheries Research Institute, Lordship, regarding all these things. So report are yet to be communicated.
Then
These
Government Council,
institutes were appointed in the month of.
MS
April.
Bhattacharya shall instruct the authorities concerned who have been assigned the task of making an inquiry in relation to the issue of formalin and other heavy metals in the fish being imported to expedite the proceedings.
Let them also file a report at the same time.
The latest report of the scientific experts shall be placed on record
Lordship.
by the next date list after summer vacation.
Pleasure, ma'am.
Supplementary list, item 45 and 46.
May it please your lordships, in terms of yesterday's order, the deputy commissioner has issued this order.
All right, let's see. Mr. Talukdar, you have a
And
copy
I'm
of the order?
told, my lord, the chief executive officer has also communicated to the petitioner to come and assume charge.
All right. And Council MS so and so has placed on record copy of the order dated
6th of June.
6 June 2023, as per which, the appellant herein, the writ petitioner Ashish Nath has been intimated to take the charge of the President Karimganj Zila Parishad with immediate effect.
This
He
is
has
the,
already received the order.
this is the,
He has already taken
He has received.
he has received a copy of the order.
the copy of this order has already been received by the petitioner. List on 22nd,
My lord.
along with writ appeal number.
Right.
Item number 47.
May please the lordship. Lordship may kindly take up 48 item first, lordship.
Yes. 48 is
Regarding the provincialization of the appellant lordship, there are 2 writ petitions filed by. the
Then this goes to that special bench. We already constituted a special bench to hear matters pertaining to provincialization.
Lordship.
This will go to that same bench.
Lordship.
We'll admit the petitions, then appeals,
Lordship.
admit issue notice. Mr. Datta, you'll be appealing for all?
So respond number one, my lord. The
Yes,
retapellation.
for the respondent number one in caveat.
Sorry, not.
No, not for respondent number one,
Private respondent. Lordship.
private respondent, for the respondent number so and so. Mr. Katniar appears for
5 and 6.
1, 2, 3, 5, and 6. For 4 MS Bhattacharya appears. List the appeals before the special bench constituted to hear matters pertaining to provincialization.
Lordship, there is an interim prayer, your lordship. In this case, the case of the private respondent was already provincialized. And all along it was under interim order.
Let that bench hear it. Let it come up before the bench.
Lordship, then a date may kindly be fixed on when the.
What is the
Because,
interim prayer?
Lordship,
What is the interim prayer?
provincialization was done under the old act, Lordship, 2011 act.
Of,
2011 act.
Okay,
Lordship, of
then what
respondent
happened?
Number 9, Lordship. And thereafter we challenged by way of this writ petition, Lordship, and in that writ petition, Lordship, an interim order was passed, Lordship, on 2/9/2016. Lordship. Since Lordship 2016, that provincialization order was stayed, your Lordship. My IA 1599.
but what benefit that gives to your client?
Otherwise, Lordship, the respondent, if my case was considered after the end of these two appeals, Lordship, then Lordship, I will be provincialized in place
So
of her.
that ultimately has to be taken into account. Till then, let him enjoy the fruits. If it is reversed, it is reversed.
He is only enjoying after the disposal of the writ petition only. Lordship.
He has already started enjoying. Let him do that. Till the
Till
special bench.
disposal of the writ appeals, Lordship, if your Lordship grants, Lordship.
We'll have to, actually, the bench will have to take the call when it will hear
Then
the
your
matters.
Lordship may kindly issue notice in this IA also the
Issue
interim prayer will
notice
be
of
considered.
interim relief also.
Will be considered.
The prayer for interim relief will be considered by the special bench.
Lordship, I'm deeply obliged, Lordship. This item 47, same. Lordship.
Same.
Lordship. Obliged.
Call कर लीजिए, देखते हैं. Let's see.
For hearing, item 44.
Your lordship wanted to know whether any rule applicable. In this case, that APSC matter, my lord, where the interviews were conducted, only on the basis of the Viva was test.
Viva was.
Selection was.
Selection.
So lordship wanted to know any rule applicable. My lord, I find, my lord, one Assam Health Service Rule 1995 is there. And as per that rule, my lord, APSC rule, APSC, a commission shall make the selection in accordance with the schedule of selection prescribed by the government in consultation with the commission. The commission may hold such case or interview and undertake scrutiny and publication and other documents as may be considered suitable. And they still valid, remain valid for 1 year. This is what it is.
Okay.
The lordship wants a copy of the rule, I think.
Presently, we would request you to wait for hearing in July. So already we have our hands full with that NIA matter. It's taking too long. So as jointly list for hearing on 25th of July. 25th July.
Well, Lord, I am telling the stories of the case in nutshell. Here are the two petitions, criminal petitions, 1 and 6. One has been filed by Saiful Islam, who is the elder brother of deceased Hasibul Islam. Hasibul Islam was accused as a criminal in a kidnapping case.
Okay.
Filed by the private respondent, that is Firdus Ali. In that case, Hasibul Islam was arrested. And he was sent to judicial custody in the district jail at Borpeta. Now, just after 2 days, Hasibul Islam, two sisters, visited Hasibul. They had talks with him and everything was found normal. Just after 2 hours, it was told to them that their brother, that the petitioner was Saiful and two sisters' brothers, Hasibul Islam, have committed suicide.
Yes.
Then, my lord, this Saiful Islam, who is the petitioner in criminal writ petition number 1, he lost an affair against the private respondents. Because at that time, he came to know that private respondents are making conspiracy with some jail staffs to kill his brother inside the jail. So in order to save his brother from the conspiracy let loose by Hiddus Ali and others, whose daughter was kidnapped by Hasibul Islam, he filed case at that time. But police did not take any action. Then he filed petition before the Police Accountability Commission in Ulubari, Guwahati. He also filed petition before SP and DC.
Yes.
But none of these authorities took any step to get the accused persons arrested.
Okay.
So he took the help of media. When media entered in the scene, then police hurriedly went to the house of Hiddus Ali. One person was picked up. He was brought to police station. After some interrogation, he was released on PR bond. Then this is the first case. So our case was initially against the private respondents, but later on it was discovered police personnels, few personnels of the Borpeta police station, as well as few jail staffs, including Ranjit Bayon, who has been made a respondent by name. He is involved in this matter. He took rupees 60,000 from me, from Saiful Islam, inside the jail, below the gate of the jail. That was reflected in the CCTV camera. And the Lanesh CJM Borpeta ordered an inquiry through Judicial Magistrate First Class Borpeta, and he found that just after the so-called suicidal death of Hasibul Islam, CCTV camera was activated.
Okay.
Before that, it was inactive. Immediately after his death, it was activated. Our case is that at that time it was active, but at the particular time, perhaps it was deactivated. So those first CCTV footage will show that I have paid rupees 60,000 in cash to Ranjit Bayon, which is reflected in the CCTV. But their case is that CCTV camera was not active at that time. Immediately thereafter, it was activated. Now, Lordship, kindly see the inquiry report of Judicial Magistrate, which was conducted as per the order of Lanesh CJM. That inquiry report, Lordship, may kindly see, it is centrally page 88.
88.
88, that is that affidavit has been filed by SP. The Lordship, item number 6. Sorry,
Why
item number
the,
3.
what is the writ petition number 6 about?
6 is for compensation to mother.
Okay.
Because Kadbhanu Bibi was totally dependent upon the income of Hasibul Islam.
Okay.
So that was that 6 is for that. Now, Lordship, for a moment, if your Lordship kindly apply your mind, Lordship would see what is the finding of the learned Judicial Magistrate First Class.
We'll try our best to apply mine.
Yes.
That's all we can say.
Lordship may kindly see page 91 bottom.
Yes.
91 bottom. It is the report of the Judicial Magistrate First Class Counsel Chief at
Yes.
Kolkata.
Yes.
In the light of above discussion and materials in hand, I am of the view that the facts and circumstances and evidence I have found and collected during my inspection and inquiry led to establish that the deceased UTP Hasibul Islam died on account of commission of suicide inside the lavatory of room number 3 at District Jail Borpeta after 1 p.m. on 12/10/21. Hence, I opine that no other cause except commission of suicide is the sole cause of Hasibul Islam death. Remarks. I have found that installed CCTV cameras of room number 3 had been activated after 12/10/21 during my inquiry. So on 12/10/21, Hasibul Islam, in our language, he was killed. In their language, he committed suicide.
Okay.
Now the Honorable Supreme Court, my lord, has said. Honorable Supreme Court, my lord, I have brought the Xerox copies for your lordship's kind perusal.
Yes, please.
2017, 10 SCC, 658, para 8 to 10, lordship may kindly see.
Yes.
Para 8 first.
Yes.
Again, there is a lack of clarity in the classification of unnecessary deaths in the category of others. What does this category encompass? We have not been provided any information in this regard by the Union of India, and it is submitted by the learned amicus curiae that NCRB should be directed to explain the difference, not only between a natural death and an unnatural death, but also to clarify the subcategorization of others unnatural deaths. On the issue of defining natural and unnatural deaths, the learned amicus curiae drew our attention to the guidelines on the investigating deaths in custody issued by International Committee of Red Cross. According to ICRC, death is the irreversible cessation of all vital functions, including brain activity. Death is natural when it is caused solely by disease or the aging process. It is unnatural when its causes are external, such as intentional injury, homicide, suicide, negligence, or unintentional injury. We have perused the guidelines provided by ICRC and are of the view that these guidelines deserve consideration and circulation by the central government and all the state governments. Para 10. It has been pointed out by the learned amicus curiae that a disproportionately large number of unnatural deaths are attributable to suicides. In this regard, it has been brought to our notice by the learned amicus curiae that in relation to suicides in prisons, the National Human Rights Commission or NHRC has published a monograph sometime in December 2014 entitled Suicide in Prison, Prevention Strategy and Implication from Human Rights and Legal Points of View. This monograph records that during the period 2007 to 11, deaths in prison on account of suicide formed 71% of the total number of unnatural deaths. Then Lordship may kindly come. So day by day it is increasing. Now, Lordship may kindly see para 54. Yes. The case law indicates that over the last several decades, this court and almost every high court has relied on Article 21 of the Constitution, and though it appropriate to compensate the next of kin for a natural custodial death, the constitutional courts can go on delivering judgment after judgment on this issue and award compensation. But unless the state realizes that custodial death is itself a crime and monetary compensation is not necessarily the only appropriate relief that can be granted to the next of kin of the deceased, such unnatural deaths will continue unabated. Therefore, what is needed is a review of all prisons with a humanitarian nuisance. Now, para 55. Over the last several years, there have been discussions on the rights of victims, and one of the rights of the victim of crime is to obtain compensation. Schemes for victim compensation have been framed by almost every state, and that is a wholesome development. But it is important for the central government and the state government to realize that persons who suffer an unnatural death in a prison are also victims, sometimes of a crime and sometimes of negligence and apathy or both. There is no reason at all to exclude their next kin from receiving compensation only because the victim of an unnatural death is a criminal. Human rights are dependent on the status of a person, but are universal in nature. Once the issue is looked at from its perspective, it will be appreciated that merely because a person is accused of a crime or is the perpetrator of a crime and in present custody, that person could nevertheless be a victim of an unnatural death, hence the need to compensate the next of kin. So, my lord, there is in some cases, I have some also other similar cases. The state always says he was involved in many other crimes, murder or kidnapping, etc. But Supreme Court says that that is not the cause. It does not give you the license to kill. Now, second thing is this, suppose, though we are not admitting, but for the sake of argument, we are admitting that yes, he committed suicide. Even then he was at the custody of the state authority.
That's right.
So they are duty bound to save, to protect him. That was not done. There is serious negligence. And third thing is this, my lord. At that time, we filed a case against private persons. But later on, it came to our notice that some persons of police, as well as some staff of Barbada district jail, are involved. So all these matters were brought to the notice of the highest authority of the state. But it remained without any result. So
There is a state Human Rights Commission functional.
Yes.
Why didn't you approach there?
Yes, we have approached, madam.
What happened?
That lordship may kindly say, for the lordship, I invite your lordship, kindly go to criminal petition number 1. Lordship may kindly see page 34 or criminal petition number 1. Page 34.
Yes. 34.
May I read, my lord?
This is Police Accountability Commission.
Yes.
We
Police
are
account-
asking State Human Rights Commission.
That was, I think that was SP was given a human rights.
This is basically a subject of State
Human
Human
rights.
Rights Commission.
But I think in the report of the learned judicial magistrate, that thing is 80 para 80, page 18, may lordship may also say again, that is in the affidavit of SP, that those references are there, my lord. Those references are there. Page 88. Yes. Page 88, lordship may kindly see, bottom. Page 88 bottom. The Honorable Chairperson, Assam Human Rights Commission was informed by this office WT.
You are reading at page
Page 88 bottom. Annexure 1.
80.
88. 88.
88 in which rate?
In the affidavit filed by SP on 8/4/22.
Okay.
SP has filed, my lord, 4 affidavits. My lord, that is also a questionable. SP has filed 4 affidavits in this case. Because one affidavit he filed, he could not satisfy himself. How he can shield the criminals. Second time again filed, third time filed, fourth time also filed. Now the judicial magistrate report clearly says all these things, and judicial magistrate has also expressed the view the CCTV was activated just after committing suicide. So, my lord, rule law is nothing but the common sense of a wooden man. It may be understood. A district jail nowadays, every infrastructures have been provided by the government, and on that particular time, in that particular time, CCTV camera was not working. So it is a very dangerous circumstance. Who is point out to the guilt of the state
Yes.
machinery?
But I have objection that the person has filed 4 affidavits to hide something. But 4 affidavits have been filed.
That
by
is,
4
forget
authorities.
about 4 affidavits,
Lots.
5 affidavits.
But it's a case of suicide.
Why was the CCTV switched off at that particular point of
No,
time?
the report says that CCTV was not functioning.
Switched
and-
on thereafter.
No.
So it's presumed that it was switched off. What happened to the earlier footage?
No, no.
What action, what inquiry have you made regarding why the CCTV was not functional on the relevant date?
Well,
What does your affidavit say about that?
well, kindly come to the affidavit of the, we filed the affidavit, they file a reply. In reply.
Forget about that.
Paragraph 6, well, they made an allegation.
Explain one fact,
Yes, yes.
why your CCTV was not functional at that point of time. And for that purpose, why didn't you make an inquiry?
Well, Lordship, kindly come to the affidavit. Affidavit filed by the SP, Malad. This is a rejoinder affidavit filed by the SP.
Page.
Malad, it is 107.
Okay. Rejoinder affidavit, Amitabh Sinha.
Amitabh Sinha.
Yes.
Lordship, kindly come to para 6.
Yes.
Para 5 and 6, Malad.
Yes.
With regard to the statements made in paragraph 4 and 5 of the affidavit in reply, the deponent denies the allegation made by the petitioner. in
It's
paragraph
not, this
one-
is
as well as the-
absolutely superfluous. If your CCTV, the core question is why your CCTV was switched off.
But CCTV footage was also checked as per the contention of the petitioner, but the allegation of giving the money.
What footage, sir? Your CCTV was switched off. CCTV was switched off totally.
No, the CCTV, kindly see, Balot, the last three line, last three sentence, Balot.
Yes.
CCTV footage was also checked as per the contention of the petitioner, but the allegation of giving money to Sri Ranjit Bayan could not be substantiated.
Yes.
Further, no complaint against the alleged threatening of our brother's life was received at the Borpeta police station. Nothing. Well, these are all afterthought, Malad. After filing of this case.
Mr. Nath, just consider,
Lordship.
he's a 20 years old boy. His sisters meet him 2 hours earlier and 2 hours later he commits suicide. Can it be understood?
Well, I can
It's a
submit.
question of human life.
Correct.
And you have been provided measures, checks and balances to ensure that nothing untoward happens to a prisoner inmate who is in the jail. He is not pronounced guilty as yet.
Correct. Well, from the reports, postmortem report and other inquiry report and other
Don't,
materials
please,
available on
please
record.
don't tell us, don't ask us to comment on those. Don't ask us. We have got fairly good experience on these things.
Well, I
Don't compel us to comment on that. How these things are managed, we know very well. Once the state machinery is involved, everything can be manipulated. But the first thing and foremost thing, why was your CCTV not functioning? And what inquiry have you made on that?
Well, in fact, the allegations are, kindly see, the allegation is that the CCTV footage reveals, according to the petitioner, that the money was given and it was recorded in the CCTV. Our reply is that, my lord, CCTV footage has been.
All right,
it has been-
all right. To specify what was the duration of CCTV footage your officer checked. File an affidavit to that effect. And you must have preserved it. Now it's an investigation. What has happened to that footage?
They said that they have checked up that and there is no.
What is the
that-
duration of the footage he has checked?
That.
All right.
That I'll ask.
And what inquiry have you made regarding the CCTV not being functional in that?
But he committed suicide in the toilet, my lord.
Oh, whatever he was, he must have been seen going. Where did he get the gamsa from?
Lordship, and my lord, after that incident, case has been registered. I have that. case
What
diary
has
also.
happened in the case?
My lord, case diary I have received, my lord. In the affidavit, we have said, my lord.
If you don't want to collect evidence of abatement, no one will
No,
be guilty.
nothing has been found.
Obviously,
Lordship.
that is a foregone conclusion.
That particular duration, I'll indicate.
All right. Then Council, Mr. Nath. And what is your stand on compensation? It's a custodial death. It was your duty to ensure that the inmate who has been arrested by you, he remains safe. What is your call on compensation?
But on the point of compensation, my lord, since the decision of the Honorable Apex Court is very clear.
Yes,
That, my lord,
he has to be treated as a victim now.
correct.
So victim has to be compensated. Victim is no more so family members.
No, it is, Honorable Supreme Court has said that the issue of compensation for unnatural death in custody is no longer accepted, right? It is already decided.
So what is your offer?
My lord, no, my lord, I.
Assessment has to be made as if it is a accident death. Age.
I'll submit, my lord, on the quantum of compensation.
Yes, all right.
I'll submit, my lord.
Then Council Mr. Nath submits that in view of the Supreme Court judgment in the case of so and so, the state has no contest to the claim of compensation laid by the petitioner in this writ petition, because the son of the petitioner, who was a young boy of about 20 years, met unnatural death within bracket suicide while being in judicial custody. He, however, submits that on the aspect of quantification of compensation, the state would like to bring additional material on record. We, having gone through the rejoinder affidavit filed by the Superintendent Police Barpeta, we find that the same is silent regarding the duration of the CCTV footage, which the officer checked so as to refute the allegation that bribe of rupees 60,000 was given to the gateman Ranjit Bayan, who was posted at the district jail, Barpeta. Specifics of the duration of CCTV footage checked be placed on record through an affidavit. It shall also be ensured that the CCTV footage is not deleted. List on 20th. Okay. This will come in writ petition number 6/22.
Item number 36.
My lord, here, my lord, the revenue has got the records, my lord. And in the morning, your lordship has directed to go through the record. My lord, so far I have gone from my lord, but definite opinion cannot be given. But only thing is that, my lord, my client has instructed, my lord, he may approach the principal secretary with the liberty to inspect the records, which are in particular matter. And I may further be allowed to place all the materials I have in the writ petition and my additional affidavit.
Okay. Then Council, Mr. Barwa
This may
submits.
dispose of, my lord.
We can dispose of the
Yes,
petition.
yes, ma'am.
Submits that the original record has been pertaining to the land in question has been shown to him, but it would be opposite if the petitioner is permitted to see the original record in the office of the principal secretary.
In the
Cardia-
secretary revenue.
Secretary Revenue,
Secretary revenue.
Secretary Revenue, Karbi Anglong Autonomous Council. And in case, after verification of the record, any fresh cause of action arises or survives, any cause of action arises afresh or survives, then, the petitioner may be allowed to file a fresh petition with better particulars.
Well, only thing is that I have referred to paragraph 10, 13, 14, and 15. These are the entries which I may be allowed to be placed before the principal secretary.
He further submit that the petitioner may also be permitted to
Yeah, no, list.
submit a representation to the secretary for bringing the relevant material to his knowledge.
Yes, stated in paragraph number 10. 13,
Whatever you may state anything. Learned Counsel, Mr. Chutia, appearing for the council, does not have any objection. Thus, the petitioner is given liberty to file a representation to the Secretary Revenue with all necessary details. Post up. The petitioner shall be permitted to inspect the original record on an appointed date to be intimated by the Secretary Revenue after receiving the petitioner's representation. In case, after inspecting the record, the petitioner is still aggrieved, he will be at liberty to file a fresh PIL.
Yes.
The present PIL is closed with the above observations, directions.
Obligement.
Item number 40.
So,
Well, I filed the affidavit with a copy to the officer.
okay. You got the copy, sir?
Yes.
Affidavit. Where is the affidavit?
The affidavit possibly has not reached.
You must have filed it now, no?
Yes.
230.
230, that's 230.
But we have seen the government made in the affidavit, my lord. Nothing is controverted as we have narrated in our writ petition, my lord. Nothing is controverted.
Absolutely not, my lord. Absolutely not. Absolutely not. My lord is not correct, my lord.
So then let's have the affidavit on
Let
record.
us- Let us see, my lord, ensure one thing. The two persons who were found to be involved in the incident were arrested. I'm sure this petition is no longer pursued for the release of those two persons, my lord. If they are thinking that because of the initial, if any, my lord, flaw on the part of the officers, the persons who are involved, persons who are arrested now, if they are sought to be, my lord, taken out, possibly that your lordship will not allow. Otherwise, when I filed.
Question here is on the bona fides of your officials' acts.
My lord, there is no allegation in the petition that there was absolute lack of bona fide. They are not on that. They are not on that, my lord.
By itself, the allegation of illegal detention of women and children at odd hours in night.
My lord,
What more allegation of bona fides is
my lord,
wanted?
lordship, kindly see one thing.
Yes.
So far as the first wife is concerned, she was asked to come at 5 o'clock in the morning. In Assam, 5 o'clock.
What heavens have falling, sir? Why not
My lord,
at 10 o'clock in the morning?
My lordship is absolutely correct. Your lordship on the other last occasion asked the SP, my lord. She said, I'm sorry, I could have. My lord.
Mr. Mazumdar, are your police officers so spineless that they need the presence of a lady at 5 o'clock in the morning? And only allegation is harboring. It's not such a heinous crime like a murder or anything. of the sort.
Murder, my lord.
Harboring against the ladies, sorry.
Her
Correct yourself.
allegations is.
Against the ladies, what is the offense charge, please?
No, not against the lady, my lord.
So we are concerned with the calling of the ladies to the police station.
She is the wife of the prime accused, my lord.
So what is that a crime, please?
My lord, the documents show that she has information, but she was hiding the information. That is how.
So all right, permit your officers to use third degree. That's what they can do.
My lord, they are only trying to.
Call her at 12 o'clock in the night, 3 o'clock in the morning. What prevents them?
And that is what my 5 o'clock here in
So
Assam is
for
everywhere, my lord.
your inefficiency, you should be permitted to allow or call ladies to the police station, even if she is having a 2 years old child. Call her at 5 o'clock.
My lord, about the 2.5 years old child, my lord, I have stated, my lord. She was there. She was the baby was
Mr. Mazumdar.
breastfeeding baby. The baby
So
was-
what was the anxiety that all the same, all the more makes your act more reprehensible?
My lord, so far as the baby, my lord, subject to my lord, concerns, my lord, so far as the baby is
You
concerned.
could have put a constable on guard that she doesn't escape.
My lord, that's what my lord. So far as the baby is concerned, my lord, I'm just clarifying about the baby. Even if she is called at 10 o'clock in the morning, my lord, she has to bring the baby because it's a breastfeeding baby. my lord.
Makes a huge difference, sir. 5 o'clock and 10 o'clock is a huge difference.
Because
Why shouldn't we direct a CBI investigation into this case? Tell us. Into the conduct of your officials. We put you to notice on that. Come out with it.
my lord, we have.
Total lack of bona fides on part of each one of your police officers, including your SP.
My lord,
These officers, these police officials of the police station should have been placed under suspension by now.
my lord,
Had it been Rajasthan, it would have happened the moment this news came out.
my lord, there is no.
It wouldn't have taken a minute more.
My lord, lordship, kindly.
Calling a female with a breastfeeding child in the police station at 5 o'clock in the morning is absolutely unacceptable. You get your affidavit, we'll pass orders tomorrow. And be prepared to face the CBI inquiry. That would take care of your all senior officers as well.
My lord, we have explained all the. allegations.
We'll take your affidavit into account. Mr. Mazumdar submits that he has filed affidavit on behalf of the respondents today. The same be brought on record. List tomorrow.
Obliged.
Can it be day after tomorrow? I'll also go to the paper. It's huge number of documents have been annexed with the affidavit.
All right, day
Day
after
after-
tomorrow.
day after.